Thank you and welcome everybody. Welcome to those people who are watching online today. You can ensure your mobile phones are muted and to remind you that photography and recording of the meeting is not allowed. I don't think that's, is that where we are?
Yeah. Yes.
Yeah, we usually have it on that screen, you see. Okay, so if we're content, we'll proceed with the agenda. So I don't think we have any apologies. However, I think you said possibly Claire might not
My
be.
understanding is I had to stand in for Claire Sugden at an all-party group just at 12 o'clock because she'd given her apologies due to not feeling very well today.
Okay, and hopefully Sinead will be able to join us shortly, although she may be joining hybridly. So any declarations of interest to declare? No. Okay, so chairperson's business, just to advise that I along with the clerk this morning, I met with Marie Breen Smith to discuss her appointment as the new chair of the Consultative Forum, working with the mother and baby institutions, etc. And sort of talk through what was happening. Oh, there's Sinead now, with the upcoming bill and how we will be engaging with them and the clerk. So that meeting only ended about 12 or so today, so we will ensure a note from the discussion will be forwarded. Okay, members, so draft minutes, just to bring these to your attention, on pages 6 to 15 of the pack, and just to ask if everybody is content that these are a true reflection of the proceedings.
Great.
Great, okay, so I'll go ahead and sign them. So matters arising then, 5.2, so strategic priorities in our proposed programme of work for 2025 to 2027. So you'll find the papers on pages 17 to 55
well.
of your pack. Oh, there's Claire. Oh, good.
Yeah.
Fair play.
Okay.
Good job. So, just give them a second to get their cameras on. So, just to remind you that at last week's committee meeting, we agreed actions in relation to our strategic priorities. So, the committee also agreed for the committee team to update the draft strategic priorities proposed programme of work, including the requested reformatting and content changes for consideration at today's meeting. So just want to see if everybody is content with the updated programme of work. Go ahead, please.
Chair, just a couple of points under this one. So ministerial briefings, welcome that the First and Deputy First Minister will appear before us once every term. I think it's good to get that down, that that's an agreement that they will attend. But I'm still concerned, and I raised this before regarding the junior ministers. Originally it was that the junior ministers would appear separately before the committee, and there was some chatter amongst committee that we were unaware of what projects they were taking forward themselves and spearheading. And I think it was a couple of weeks ago there was a discussion around, well, they're maybe not doing that, this mandate. Is there any point in pushing that further, that we'd like the junior ministers to come before committee?
Yes,
Chair. We spoke to TEO following that meeting and asked them for clarification on the roles and responsibilities of the junior ministers. We are yet to get that. We also asked them about junior ministers' attendance at meetings. In the past, as you say, junior ministers did attend more frequently. And so again, we are awaiting response from the department on that, but we have gone back to them on those specific points.
Because if we could press on the issue, there was nobody in committee could turn around and say these were the issues the junior ministers were leading on. I think it would be good for us as a committee to understand, have they been allocated topics, have they been allocated sections? If so, what are they? Because we're certainly not aware of it.
Okay, so it's in hand. Thank you very much to the team here for taking that forward. Okay, members, so we're going to move on to our first oral briefing session, stakeholder panel session around the Victims Payment Scheme. So we can go ahead, please, and bring our visitors in, please. So members, I just would refer you to pages 57 to 58 of the pack for the clerk's brief, pages 45 to 76 of the pack for the briefing paper from Relatives for Justice, pages 3 to 9 of the table pack for correspondence from the Justice Committee. And so I am...
Can we just give a
Yes.
few minutes,
Yeah.
Chair, just so I can get Kenny and David
Yeah,
brought in,
okay,
if
so we'll
that's
just
okay.
take our ease for a second.
Yes.
Members, just while
there
we
they are now.
take people, let people come into the room. Okay, so members, we are welcoming to the meeting Miss Andre Murphy, Deputy Director of Relatives for Justice, Mr. Rory Hotworth, is that right? Okay, a caseworker for Relatives for Justice. Is Sandra Peake, is she online? No,
We're expecting Sandra
we're
to be here.
expecting.
I will go out and
Okay.
Sandra. Okay.
And virtually we are welcoming Mr. Kenny Donaldson, Director of the South East Fermanagh Foundation, and Mr. David Taylor, Welfare and Advice Officer at the Eli Centre. Okay, so you're welcome, and welcome online, gentlemen. So I think we're just waiting for one more panel member, but we'll go ahead. So if you would like to make some opening remarks, we've got 3 panels today, so if you can keep them as brief as possible, but especially since you were able to send us some written notes before. Okay, please, do you want to go ahead?
Thank you so much, Chair, and thank you to the committee for inviting Relatives for Justice here today. But it's a really important subject, and as you can see from our evidence, it's quite a complex matter and something that we welcome the opportunity to give evidence around. I also want to acknowledge that there'll be people in the room who are affected by the issues that we're talking about or love someone who has been, and I just want to acknowledge that before we begin.
Thank you.
I think, as the committee knows, the scheme is up and running quite a while now. There are a lot of very committed people working on the scheme, both in the Payments Board, in the VSS and across the organisation supporting applicants, and that work is by dedicated and wonderful people. So the issues that we're raising today are around strategy and around structure, and absolutely nothing we're saying is about the commitment of those who are working in this field. I suppose it's important to notice the gaps, because what we're noticing are harms, and we're noticing people impacted by those gaps and those harms, and we've provided the committee with a snapshot of some of those areas of concern that we have. We have concern around victims of conflict-related sexual violence, around those affected by punishment-style attacks, by those affected by the use of rubber and plastic bullets, and in particular we're concerned by the experience of the bereaved of the conflict who are applicants to this scheme. And I think it's important to acknowledge that all of those that we're supporting meet the 2006 Victims Order. We all work with those individuals in a range of other services as well, but they have a particular experience of this scheme. My colleague Rory, who manages our team of dedicated caseworkers, is going to give you a run through some of those case studies now, just to give a flavour of the kind of issues, if that's okay.
Thank you, but we got them in the pack, so I
Yeah,
think you can assume that we'll have read them, so if you can be as brief as possible, please. Thank you.
So yes, as you said in the pack, the first case study we submitted highlights a victim of a plastic bullet who was shot from behind, deliberately arrested and later charged with throwing a petrol bomb. And then these charges only arose after the victim sought compensation at the time, and has led to the panel to deem them ineligible under Regulation 6.1. So as I say, although the appeal panel sought evidence suggesting the conviction was unsound and acknowledged the victim's circumstances, they said they were bound to accept the state's version of events. And as a result, this has left the victim feeling disbelieved, further isolated and ultimately denied recognition of their life-changing injuries. And as the second one, as Andre mentioned, we had a case that highlighted the flaws in the Victims Payment Board handling of paramilitary style attacks. So what we're finding is the VPB has taken a narrow and default blanket approach to exclude these attacks as not troubles related. So in this case study, the victim was caught in the wrong place at the wrong time when they were shot by a dissident group opposed to the peace process. They were assessed with a combined permanent disablement of over 100% and have been left with daily chronic pain and psychological harm. Yet they've been denied recognition and support from the scheme. And this is a reflection of the wider picture we're experiencing, where a significant group of victims, who are mostly young men from working class communities, who have been subject to brutal violence, are being excluded from recognition and reparation under eligibility. And then in terms of the bereaved, if I can just continue with two. Yes, I'll keep it brief, don't worry. This case, so the case involved a bereaved family where, despite 4 panels reviewing the same information and circumstances, 2 applicants were accepted while 2 were rejected, with unsuccessful decisions stating that because a sheet was placed over their loved one's body as they were carried out, they were not eligible as the immediate aftermath. So the inconsistencies in how these regulations are interpreted by panels are not victim-centred and cause significant harm and re-traumatisation. So in this case, it was over 3 years of forms, assessments and an appeal process which has led a bereaved family to relive the incident repeatedly. And just the last one I'll finish on is this case involves 2 bereaved applicants who witnessed the death of their loved ones in the immediate aftermath in hospital after they'd been shot. So one was deemed ineligible because they stated in an assessment that their loved one was wired up like a robot, and that's a quote, and had therefore received medical treatment and were not in the original condition as at the scene, whereas the other applicant was ruled eligible even though information was provided to show they were on life support. So this again is highlighting the inconsistency in decision making and broader issues of a failing to adopt a victim-centred approach and the further harm being caused to bereaved applicants in this process. The process is re-traumatising victims by requiring details and distressing recollections of the incidents, with questions asked about how long it took to arrive, what they saw, whether medical care was given, and has become for many a re-traumatising, cruel and dehumanising process.
Okay. Thank you. I'm going to move on because I need the other 2 and then Sandra will be here shortly. Kenny, would you like to make some opening remarks, please? Thank you. Oh, I can't hear you, Kenny. Go ahead.
Apologies, Chair.
Go ahead, please.
Chair, yes. Just again to thank the committee for the invitation today. It's a good conversation to be part of. I'm not going to labour who we are as a group, but to say that at this stage, the applications have been submitted, and we've submitted over 2,100 applications, approximately 17 to 18% of what has gone into the overall scheme. And there are, obviously, there's the good, the bad and the ugly of the scheme to date. I think we all would recognise that. There have been some extremely positive pathways for people, and ultimately outcomes have been reached which will have a transformative effect on their lives, and others less so. The issue of the bereaved is obviously an outstanding issue. It's a sectoral issue in the sense that this scheme was never in many ways ever developed with the bereaved in mind, and we're attempting in many cases to try and shoehorn people into a scheme which does not have the flexibilities which are required. So it's a separate piece of work. I would suggest to the committee here to redouble efforts around the issue of a scheme which is about restitution, which is about acknowledgement of the bereaved whilst they're still in this life, because many of the first generation victims are coming to the very, very latter stages of things in their 90s and late 80s. Can I also say today I want to put on the record that I have a concern with a scheme from the point of view of its national status, and I would question whether that is wholly accurate. It required Westminster to pass this scheme at a national level. It would never have been passed locally, and we know that around the table. The issues of eligibility would never have been able to be resolved. It was passed nationally. But when we look at the number of applications that have been submitted to the scheme outside of Northern Ireland, they are less than 1,000. And that, in my mind, illustrates the lack of understanding, of awareness that exists beyond this place with all those others who've been impacted by the Troubles. If we look at the GB context, there are people who have been impacted by atrocities over there. We have many people who have left Northern Ireland from right across our community to live across there who've been victimised here. And then there's a constituency of people within the security forces, the armed services, who have been here, 300,000 some, in terms of boots on the ground in the regulars. And that's a huge cohort. The Republic of Ireland is also something that concerns us, and around the Farskell situation, where 2 brothers in the same household, one can be eligible and one not, because one happened to be born in Manchester and lived the first 10 days of his life there, and the other to have been born in the Republic and not being eligible.
Okay, thank you.
Sorry, Chair.
No,
I just want to say, sorry, one final thing, that I want to say that in terms of the staff that do operate across the scheme, those whom we have dealt with, we find are trying their best against a very, very difficult backdrop and circumstance that was not of their making.
Okay, thank you. Okay, David, sorry, I see you're joined by somebody else in the room there. Do you want to introduce?
Yes, sorry, it's my colleague Ivan Bingham, who's here in an observing capacity, if that's okay.
Very welcome.
Okay.
Please make some opening
you.
remarks. Thank you.
Yeah, okay. Well, first of all, thanks to the committee for the opportunity to take part in this session today. We appreciate the invitation and hope it's certainly a productive engagement for everybody involved. My name is David Taylor, and I'm employed as the Ely Centre Head of Welfare Services within the organisation. My remit obviously involves overseeing the work of our welfare team and coordinating the day-to-day activity. of welfare staff members. The service that we offer, obviously, like others, is a free and confidential service, and our particular unit of the organisation provides advice and assistance on all welfare issues relevant to victims. A brief outline about our organisation. It was formed by relatives of the injured and bereaved of the 1987 Enniskillen Remembrance Day bombing. The founding member being Jim Dixon, who was a seriously injured survivor of the Enniskillen bombing. And obviously the focus for our organisation has been to support those who were impacted by the Troubles. And over the last 30 odd years, the Ely Centre has developed into a proven charity, providing care and support for victims and survivors, their families, veterans of the Nazi forces, and security force members from across Northern Ireland and indeed the wider United Kingdom. And we have a client base of over 2,600 clients who access and are provided with support on an annual basis by our organisation. We are a registered charity which provides various forms of support, including health and wellbeing support, family and community services, and welfare support services, and facilitate advocacy support for individuals and families who suffered as a result of the Troubles. Our welfare service is obviously an extremely busy one, and a considerable focus for our staff since its inception has been the Troubles Permanent Disablement Payment Scheme. This stands alongside the other forms of welfare support offered by ourselves. The scheme support includes direct assistance with the completion of application forms, respond to queries on behalf of applicants and attend assessments with them, and indeed assistance with appeals if required, and holding outreach events within local communities promoting the work of the scheme and providing information on the process. As you will understand, obviously the nature of the work involved in the Troubles Permanent Disablement Payment Scheme, it's obviously very sensitive in detail, and it's a very difficult process for any applicant, as they recount in extensive detail information around the incidents, or in cases multiple incidents that they were directly affected by as a result of the Troubles. These incidents have resulted in significant and permanent impact on their lives, either physically or psychologically, and indeed many cases, both instances. With this in mind, we certainly take a professional and compassionate approach to support that we offer to our clients, which is vitally important in building confidence to allow them to go through that process. And whilst we will go into more detail on that, the issues that are involved in the scheme today, we do recognise as an organisation that there are challenges that do exist. And probably one of the most prominent for ourselves is the one of time delays involved in processing applications, which does cause deep frustration for clients, particularly given the age of many of our clients and the passage of time involved. And we do accept, however, that certainly the Victims Payment Board staff have a challenging job in processing and gathering data. We also believe further work is required in terms of more extensive communications and raising awareness of the scheme, especially outside Northern Ireland. Just as a brief, note before I finish here, I certainly want to acknowledge the support that's offered by organisations such as VSS also, in terms of the funding that they provide for organisations such as ourselves in providing that assistance through this scheme process. And at this point, we're obviously due to finish, in terms of applications next August 2026. But it would be clear to us that further support is required as time goes on after that. Those support will be required for applicants after 2026. So I would ask the committee to be conscious of that going forward in the time ahead. As I said, there will be more opportunity to go into, I suppose, more intensive detail on some of the issues outlined, but I thank the committee for the engagement that we're being permitted for today.
Okay, thank you. Okay, let's we'll get into the Q&A session now. So thank you everybody for your opening remarks. So one of the purposes of the scheme is to promote reconciliation between people in connection with Northern Ireland. I'm going to ask all of you, to what degree do you feel that this scheme is actually delivering on the reconciliation piece?
I think in terms of reconciliation, often it's about acknowledgement, and it's about having your experience of harm acknowledged, and then being able to engage with processes after that. And reconciliation hopefully will be a byproduct of some of those processes. If we have active exclusions of many members of society, or if we feel that a harm is not over and it's being re-perpetrated as a result of a scheme, then the potential for and possibility of of reconciliation is going to be impacted by that. So for the bereaved who are engaged in multiple processes of denial of experience, whether it's access to truth, justice or accountability, no matter who the harm was perpetrated by, if they are also engaged in this scheme in parallel, and Kenny is right, it isn't designed for the bereaved, but we can't be Pontius Pilate. We can't just say, oh, it's nothing to do with us, Gov. We have to accept that there are thousands of bereaved relatives engaging in this scheme. 31% of our applications are from the bereaved, because they want to be acknowledged in that. If this scheme is saying to them, we don't believe you, we are going to exclude you because of your perceived proximity to the death of your loved one. If you are consistently undervalued in terms of the impact of that trauma on you, that is going to reduce any capacity for reconciliation.
Okay, no, thank you. Kenny, please. Did you hear the question okay? Yes?
Yes, I did indeed. I think, look, reconciliation is often attached to much of what we do with victims and survivors, and sometimes I question why. We have a Legacy and Reconciliation Act is the important term to also use within that language. And I suppose it's a reconciliation with whom? Because if I can perfectly understand if someone feels that they have been wronged by a state agency, and in receiving a form of reparation through this scheme, that could aid that relationship. A form of acknowledgement has taken place between who they believe to be the source of their difficulty. But I think we also have to acknowledge that the prescribed groups are not dipping their hands into any pockets. So there is no base for reconciliation between many of those who've been impacted by terrorism and anyone, because it isn't, in a sense, that relationship is different. So we have to look at what actually this reconciliation means. And there is still no working definition of what it means in the context of victims and survivors. It means different things for different people. But what we ultimately say within our group, what this is about is trying to give victims and survivors the empowerment to reclaim control. Because when violence strikes, wherever it comes from, often control is lost. So it's about the empowerment of the individual to live a better and more fulfilling life.
Okay, thank you. Kenny, David, please. Same
Yeah,
question,
thank you,
please.
Chair. Chair, I think probably we're at this moment in time very early in the process to try and make any sort of form of judgment as to whether it helps deliver reconciliation. And I'm not sure we'll ever achieve that, if I'm being honest with you. I think the scheme itself is, as already been outlined, it's a form of acknowledgement, but it doesn't necessarily remove the clear hurt that exists as a result of what was inflicted on many in our society as a result of the Troubles. And I think when we even see, in the current day, attempts to try and justify what happened in the Troubles, that in itself serves as a barrier to reconciliation within our community. And that challenge, whilst that exists, will continue to cause, that raw trauma that certainly we see on a day and daily basis with the clients and victims that come through our door looking to support. So I just at this moment in time, I think the term reconciliation is something that it's not a word that I would use at this moment in time. Certainly in my experience, I haven't had any client, that has received some form of payment or recognition say to me that they feel reconciled by it, but certainly it's an acknowledgement more so than anything else. And I think we need to be conscious of that. I don't think it's a principal aim of it maybe, and whilst it's an aspiration, I certainly feel it's a small acknowledgement in many ways for what people have experienced as a result of a very terrible, heinous act committed on them or a family member as a result of the Troubles.
Okay, thank you. I'll go to Kenny for start and then I'll go back that way. Kenny, I just want to ask your opinion on the fact that the scheme or the applications, the ability to submit an application will close then on 31st of August next year. And I know that it was an extension, but is it of your opinion that there still needs to be more time for people who've been impacted and injured, past 2026? Do you think that we should extend it again? Or do you think that you as an organisation are actually able to capture a good lot? Or you'll be able to capture them by then?
It's a good question, Chair, and I think maybe this is the wrong way of putting it, but I think as organisations, we have almost fished in shallow waters to this stage. and we have those whom have been attached, if you like, to our organisations or to victim survivor services over the years have largely come through at this point. Some haven't, but largely they have. The leaflet drop did bring forward some additional cohort at that stage. But what I would say to you now is, and I feel that the committee could bring this pressure to bear, there is a need perhaps to do a mapping exercise of where applications are coming in from. So by geographies, but also in terms of across particular constituency groups, to establish if there are any weak points in the system and what additional resources should be put to trying to increase awareness and information around that. Because we feel, I've always felt this, that the crime is not someone opting out of applying for something. The crime is that they never knew it existed.
Yeah.
People should have the rights to opt in or opt out to something, but they only do so if they actually have the information to begin with.
Okay, thank you. So same question, but Andre, but even if you want to pick up that piece around the communication as well.
I think the communication is important. I also think you need to see that there are multiple processes happening for families and for the injured at the moment in the broader kind of context of legacy. So for many people who are overwhelmed and injured, they are going to have to prioritise which process they are engaged in. So when we are not dealing with the past right, this process sits in the middle of that, and for them we need to be far more available to say we need to extend this, we need to ensure that we maximise the potential. And you know, Kenny and David have both talked about people who would be excluded, but if there has been an approach which has said that there are certain swathes of society that are dismissed, alienated and rendered invisible, I would include punishment shootings within that and those type of attacks. I would say that from the day and hour that happened to them when they were 14, 15, 16, that cohort in working class areas were deemed by everybody as all kinds of names, and they have grown up with that. They're now in their 50s, 60s and 70s. For them, the dealing with the past debate may not seem like it's relevant to them, but it absolutely is. And we need to ensure that we start reaching into those places and creating a healing process for them as well. And that is without what we are saying about the bereaved. If we are coming up with a process that does deal with reparations for the bereaved as part of our approach on dealing with the past and the broader discussions that are happening at the moment on the Legacy Act, then this scheme and the discussions around it will feature within that as well. So we need to see how all of that happens in parallel.
Okay, thank you. David, please, if you can respond.
Yes, and thank you, Chair. Chair, certainly as an organisation, it's something we think should be considered. And I mentioned in my opening remarks, we felt there were issues around communication. Even, you know, there are areas, and we've seen this even through meetings that we have had with the agencies involved, and that there are particular areas where maybe there are a limited number of applications, and that includes even GB. There was quite a number served here from GB that obviously there hasn't been the numbers probably certainly that was expected in that regard as well. I think also there is still that lack of probably knowledge about what the scheme actually entails. There's a number of reasons for maybe, you know, people not applying. One is about the lack of knowledge of it, and despite the fact there was a leaflet drop, in many instances people maybe got a leaflet and put it aside without actually going into the substantive detail of what was included in that. We also have a situation, I think, too, where there are people within society who have been nervous about actually going forward with the scheme. One of the reasons may have been that they're obviously already, and have already related this, suffering considerable hurt and trauma as a result of what happened in the particular incident or instance that they endured as a result of the troubles. We also find a situation too where they don't want to receive any further disappointment, because that in itself places a considerable strain on their welfare, and as a result of that there's a reluctance to go forward for fear that they maybe do not, you know, receive a positive outcome. And that's something I think we all should be conscious of as one of the barriers probably to, you know, people applying for this scheme is that just the receipt of further disappointment. You know, they've maybe felt they have been left behind as a result of, you know, what happened to them at the troubles, and they didn't get the support throughout that period, whether it be grief related or injury related, and they find themselves in a situation where they can't really take any more, and as a result of that they have been reluctant to go forward with the scheme. So it's certainly, I feel, you know, and we feel as an organisation, something that should be looked at. But we also, in doing that, there needs to be a strategy going forward in terms of how that engagement and communication happens to try and deliver upon a more positive outcome in terms of people coming forward to apply for the scheme.
Okay, thank you, David. Deputy Chair, please.
Thank you very much, and thank you to each of you for your contribution today and for the work which you are doing in your respective organisations. May I ask first of all 2 questions I'd like to ask? First of all, to what extent do you meet and cooperate with each other to determine the commonality of issues with regards to the scheme, and have you identified those issues which each of you have common ground on? And secondly then, and I think Kenny was the person that raised this issue about the ending of the scheme, or the end date for the scheme. What are the main structural changes that each of you would like to see between now and the end of the scheme, whether it's 2026 or some future date?
Okay, who wants to start with that? Go ahead.
They're great questions, and would certainly I'd love to bring them back to the team to have a chat to be able to respond with what they're all saying. We have met even in the structure of it, in terms of the operationalising of the scheme. All of our organisations have developed friendships and have developed good working relationships as a result of that. But it's very much on the operational side that we have developed those and can have a meaningful input. In terms of the strategic kind of decision making that has happened in terms of things like eligibility and things like that, we anecdotally all bring similar stories but can have very little impact in terms of the structures that are there, and there is a sort of, that's where the gap lies. So we will all see, for instance, the emergence of the guidance around the unwritten guidance around plastic bullets, but our common experience around the use of plastic bullets and the lack of eligibility of those who experience that harm. Similarly, conflict-related sexual violence, similarly, and it's constantly on the agenda around the bereaved. We will raise anecdotally really disturbing and distressing treatments of people through the process, because it is set up the way it is set up in terms of the evidence gathering, in terms of the eligibility establishing, in terms of establishing the percentage of disablement or whatever. And that can be very humiliating. It can be very denying of experience. And we will all anecdotally join that together, and that picture is there, but there's very little impact we can actually have in terms of that. And that can be frustrating. In terms of the structural changes, I think we need to get those things right as well. So, you know, if we were writing that, if the British government, who's not in this room or in any room where this scheme is discussed, even though they wrote the legislation, even when it comes down to funding, they're not in the room for it. If we were having the discussion now and saying, how would we write this legislation to ensure that it actually is victim-centred, to ensure that we don't see these ritual humiliations and degrading of experience or denial of experiences of harm and in terms of injury, if we were going to rewrite that, how would we do it? So I would like to see that conversation to happen in terms of the deadline, so that we can have an honest conversation about it. If we're talking about dealing with the past, why not put this in there and ensure that we can at least make amends and do better over the next coming time?
Do either of you want to comment on that, Kenny or David?
Yeah, yes, Chair. I suppose just to feed on to that particular point, I think, look, what we suffered from the point of the agreement, if truth be told, at different junctures, we've had a very, very piecemeal approach to all of these issues. And there are temporary winners for a period of time, and there are a lot of losers in situations. And it's quite understandable that if you are a victim survivor, you will deduce your experience on the basis of where you have got any progress from. And sometimes when you see someone else having a degree of progress, even though it may not be a very deep progress, but superficially it looks like it's progress, then that can become very, very difficult for people. And the issue of the bereaved was known some years ago was always going to be a problem with us, and we still haven't quite resolved that matter. And it would be a crying shame, in fact, would be an indictment on us all, if we don't resolve the issue of the bereaved. Let's remind ourselves that in the 70s and 80s, the level of criminal injuries compensation that folks were receiving was paltry, if at all. Those who were aged over 18 years of age were discounted because they were minors. And you hear sometimes the argument made that there's so many different pathways of compensation reparation for victims and survivors. There are a lot of people who fall through the cracks. And if I could just speak to one particular individual, a case that would, and there are many, would break your heart. This was of a lady whose husband was murdered. She then remarried and she had her war widow's pension taken from her. The lady then remarried and she was within the cohort who did not receive her war pension back. It took the death of her second husband for, by default, the state then to offer her that war pension at that stage, but she had no acknowledgement of the 30 plus years where she received nothing.
Yeah.
And she is someone who, with this scheme, has actually been in a circumstance where she had to provide an oath that she actually was present in the hospital with her husband, and that oath has not been accepted. So she is now being told that you are not only ineligible, but you're also a liar. And that's challenging. So there are cases like that which are very, very difficult. But as I have said before, there are also others who have had a positive experience and have had a transformative effect. But we need to look at it all in the rounds.
Okay, thank you. David, anything to add to that, please?
Yeah, well, some of the stuff already has been reviewed that I mentioned that I would reference, but certainly in terms of engagement, there is what I would term regular engagement, whilst it's not on a weekly basis. There is, quarterly engagement through sectoral implementation group workshops, etc. That's certainly, I find of benefit. Particularly when you hear maybe some of the examples and stories of what is affecting other organisations and the support that we offer. So it's useful to, I suppose, learn from that experience, that it's not just ourselves are experiencing those issues, but we do have engagement as organisations and with the statutory agencies involved in the scheme. In terms of structural changes, I suppose there's a number of issues. I suppose the legislation itself, there's I suppose a number of issues that are raised in that in terms of the regulations that are applied, particularly in terms of the attendance or at or an immediate aftermath of a troubles-related incident, and the term loved one. Like some of our clients, for instance, have not received a positive outcome, as a result of these regulations. But that isn't the fault of the Victims Payment or anybody, but it's purely based on the legislation that was, applied, and maybe that was something that we felt at the time Secretary of State's review could have maybe looked at, but that wasn't the case. So, just to give you a few examples of that, next of kin relatives who were not at the scene of a TRI but have suffered serious psychological trauma as a result of that incident, and even work colleagues of victims who may not have a family connection and weren't considered loved ones, but were there and seen the very real impact of what happened on that particular day, and they have been denied eligibility because of of that, despite the fact they're suffering from extreme trauma as well. And there has been mention about the bereaved and the fact that they aren't necessarily recognised in this scheme in the way that we look forward to look towards. So maybe some of the safeguards within this scheme could be applied to a bereavement scheme, and I'm not going into specific detail on that, but it's something that should be looked at going forward. And I think even from another point I would raise, I suppose, from a structural issue, it's more about, again, the time frame that I outlined and the length of time that it does take to process an application. Is there a way of reviewing how that information is accessed, and can that be done in a more swift manner that eases the process for applicants? Because I say the biggest frustration that I see on a day-to-day basis is the length of time and the lengthy periods where there's silence, I suppose, in terms of any application because of the process that's been followed. And is there any way that the requirement for information from the various agencies that supply confirmation of existence at the scene, medical records and things like that, that are all used to support evidence, is there any way of looking at that being improved going forward for the remainder of the scheme?
Okay, thank you, David. I'm going to move on. Harry, please.
Okay, thank you very much, Chair, and thanks to each of you. Just going to keep it simple and one question to yourself, Kenny. You mentioned 2,100 applications and you said good, bad and ugly. Could you maybe give us a wee bit more breakdown on that, please?
I suppose, thank you for the question, Harry. It's more around, I suppose, the experience that people have had, in the sense of some have to say, a relatively smooth process, as much as you can say smooth in these circumstances, but they've known, I suppose, everything happened in the way in which it should happen, and they have come to an end of it and have a satisfactory outcome at least makes some form of acknowledgement. Others, as I say, that case that I've just referenced, and it's not the only case, people where you just feel it in your gut. There's an unfairness to it.
Yeah.
There's an absolute, if that's the best we can do as a society for an individual like that in her 80s now, then I really question what we're doing. But again, I would say that the difficulty with this scheme is as well, and perhaps this is something for the VPB to consider. We will hear what we're relaying today, and of course there's a lot of challenges and a lot of difficulties. What's not heard enough as well is the positives around what the scheme has actually done as well for people.
Yes.
And for those who have had a good experience, there's been transformative amounts of finance that are really going to change the quality of life within that family, and recognition critically for people of death in many situations who will have 10 years of a commitment thereafter. So we need to be fair about this and talk about this scheme in its fullest terms and not merely focus upon the negatives. There is a mixed bag across the piece.
And just a wee supplementary, please.
Fine.
Would you say, at percentage-wise, it's equal, Kenny, or is there more good than bad, to use your terms?
I think in terms of success levels, we're running sort of, I suppose, 66 to 70%, that sort of figure. But you also know that whenever you're submitting some applications, you know that in terms of the actual scheme criteria and how tight and rigid it is in a particular area, that the likelihood of someone being deemed eligible is going to be very, very challenging. But you nevertheless, as an organisation, as a service, must put your very best case forward for that individual. It's their right to have their experience reflected in that manner and to put it on the record. So it's I suppose what I would say, Harry, if I can use it like this, if we have, say, out of 2,100 applications, 1,300 of those, say, are successful, then the average amount is somewhere in the region of £30,000 to £40,000. If you calculate that up, that's circa £40 million. That's going into the pockets of victims and survivors that otherwise wouldn't have done.
Yeah.
And that's for an investment by government of around about £1.5 million over a 5-year period for the staffing that has done that. So it's a good return, if you like, on that. But there absolutely are people whom are not relying. That's obviously where we're focusing particularly on today.
Understand.
Okay,
yeah.
thank you.
Appreciate that. Thank you, Kenny. Thank you.
Did you want to add that, or
Just
Yeah,
a little,
please.
because someone could engage in the process and come to the end and be successful in their application, but the process has been horrendous for them. I included in here the example of a young woman who was 3 when her mother was killed and was carried over the body of her mother. One of the press reports said that she was asleep. Her father had carried her when she was asleep. That was used against her so that she was turned down. That woman was very heavily pregnant at the time. I can't tell you what that did to her. She was subsequently successful at appeal. So on the face of it, it looks like she was successful. But actually what happened, this was a horrific process for her that she would never encourage the next person to participate in.
okay? Thank you, Carol, please.
Oh, thank you, everybody. And I suppose it's just on that theme. I mean, the question I would ask of each of you would be, you know, what would a standalone scheme look like? Because it's easier at times to say what you don't want. So we'll all accept that most people, if not all, have found the process traumatic. A lot have found it humiliating, and others are probably reluctant to recommend the others to go through. So what would you like to see improved in a standalone scheme? And the kind of follow-on question would be in terms of the disparity that arises depending on the circumstances, or indeed how the reports are internalised and then processed, and depending on which panel is dealing with a particular case. There seems to be the gaps that you spoke about at the start. How could that be corrected in a standalone scheme?
Do you want to go ahead, Andre, and then we'll go to David, please?
Sure.
Hi, Sandra. Very well.
Apologies.
No problem.
I think it's again a great question that would require us all to come back to, and it would be nice for us to come back to that question in terms of it. I think there's a fundamental in terms of acknowledging that we have a really good definition of victims with the 2006 order, one that acknowledges all experience of injury, irrespective of your background and who the actors were that caused the harm. This scheme has a default position of what I would say is a pro-state narrative. So a contemporaneous RUC report from the time is believed above the person who experienced the harm. So a standalone scheme that is actually victim-centred, that understands how the conflict was experienced in a really contested way, that we will all, depending on our experiences, come at it from very different experiences and understandings of how documents were recorded, what evidence was recorded and whatever. So a scheme that actually engages with the complexity of how the conflict was experienced and respects the 2006 order would be useful. In terms of a bereaved scheme, I don't think any bereaved relative should have to say I was injured. I think there needs to be the dignity afforded to them to say that as a result of losing a close loved one, you do not have to prove the extent of your trauma or the injury that it has caused or what you're living with right now. We need to do that in a human rights compliant way and in a way that affords dignity to all of those families, and I would say that it isn't done in this sort of judge-led way that we currently have, because I don't think that is particularly useful for these types of schemes, and we see that across other schemes, not just this one, I think. And I can't remember the second part of your question.
Well, it was about the disparity that arises depending on particular cases, because that's something that we would get as MLAs representing constituents who are trying to access this, even siblings within the same family.
So Rory was speaking about the case of a man who was killed around the corner from the family home. 4 siblings applied. 2 of them were successful. The other 2 were told that they all arrived at the scene at exactly the same time and saw exactly the same horror of their father. And 2 of them were turned down at the first stage because they were told they only saw him being carried out on a stretcher, his boots, and covered in a blood-soaked sheet. So they were turned down. Those 2 were turned down. 2 were successful with a different panel. Is it yesterday that the appeal was heard, and the second 2 then were successful when they were heard by other people within the same scheme? That should never have happened to that family. What that has done to them and their dynamics, it just puts people back. It adds to the trauma, it adds to the perceived injury, and it's just none of us could consider that fair.
Thank you. David, do you want to respond to that, please?
Yeah, just in terms of the standalone scheme, at this moment in time, our Director of Services isn't here, obviously, and I wouldn't want to go into specifics of something like that, so I think it would be preferred just if we can respond to that probably in more detail at a later point. But I think probably one of the things I would say on it is that there are some within society that still aren't recognised. We have talked about the bereaved, but even those that have offered support in a caring capacity for those that have victims that have suffered serious significant injury as a result of the troubles, and even those that have found themselves in hardship as a result of what happened to them. There are a number of probably cases that potentially could be looked at and something like that. And in terms of the disparities, it is a concern that we have, and it has already been referenced about the fact that you could have siblings that have went through the exact same situation, but have found themselves where one has been successful and the other hasn't. And it may have been that different panels looked at those particular cases. But that in itself, it causes me, certainly in our organisation, significant concern. It shows a clear disparity and maybe a potential approach been taken in that regard, where somebody's been through the exact same thing, they've showed the same level potentially of trauma as a result of what happened, and one finds themselves in a situation where they're successful and the other isn't. Now, I also don't want to go into too many specifics in that regard, but in even more recent times we've been discussing cases like that, and to me, again, that creates, even within families, difficulties, where you find one person's hurt been recognised and another's not, by a panel, so to speak, and it's and this is never what that scheme should have been designed to do. This was to provide acknowledgement and some sort of suppose, way of trying to recognise what people have been through. But when you have decisions like that, it certainly shows a clear disparity and flaw that's in the process at this moment in time, and that's certainly something that needs to be looked at.
Thank you. Sandra, did you hear the question okay?
No, I didn't.
Oh, right, okay. Do you want to maybe repeat it, Carol, or we'll bring you in maybe next, please?
So what would you like to see improved in a standalone scheme? And then how can we improve the disparity that arises depending on which panel is dealing with a particular case? And the examples I give where siblings in the same family have been treated differently.
Yeah, okay.
I mean, we've obviously had a long-standing relationship in relation to TPDPS, in relation to the intergroup campaigning for it. And I would have seen it in relation to the benefit that that has brought. It's a groundbreaking scheme, it's new. I think there have been many difficulties along the way, some that could have been envisaged, some that couldn't. And I suppose the big question is around how those are changed quite quickly in relation to making the scheme much more, I suppose, visible in relation to whatever changes are required. I mean, there was an evaluation. It took a year, and it took a year for the findings of that to come out. And I appreciate there are many complexities around that. I would share Andre's view in relation to the bereaved. To me, are the biggest area that fall outside the scheme, and it's grossly unfair. There's an inequity. People who have witnessed the murder can receive it, the actual family may not receive it, and of course you have differences in relation to siblings. I think the process of going to appeal is very traumatic for people, and there's a real sense of are you believed or you're not, and there's also in terms of a very direct link in relation to service provision, because people we have found have been taken back right back to that time, and that has been very damaging to them, and there's a ripple effect on into the family. I think the other thing that needs to be seen is in terms of appeal is that there's no higher body, and Social Security is a higher body beyond appeal. So the appeal is to the TPDPS, the Victims Programme Board, but actually there should be a higher body for those cases that should be looked at in the same way as a social services appeal system. And I would want to see a scheme that is introduced for the bereaved, that's bespoke to the bereaved, that recognises the bereaved. And I think that should happen because it is very difficult, I think, for families, and it ties here to recognition, to acknowledgement, and that's grossly unfair.
Okay, thank you. I'm going to move on. Brian, please.
Thank you, Chair, and thank you all for your attendance today and for the work that you're all involved in supporting victims. So you've certainly helped us in our questions that we'll be asking the officials after, so it's been a very helpful briefing. I've supported various people who've applied to the scheme, some successful, some waiting, and I'm told the average time, is counted in years, several years typically for an application to go through, and I appreciate that's very frustrating. The scheme, I suppose, to be generous, we could say it's a well-meaning scheme, but there are many gaps in it, and as people are coming forward who are genuinely impacted by the Troubles and then finding they were falling at the edge of criteria and having to make the case, and you've fought for those people. Just to say it, obviously myself and my party absolutely support that this should only apply for people who were injured through no fault of their own, and that it must be for genuine victims, innocent victims. A couple of things I want to pick up on. You mentioned about, you've given a case study there of sexual violence related to the Troubles, in that case for a serving RUC officer. I do feel this is a massive untold story of the Troubles. Any situation where there's people having an interest in the breakdown in law and order provides the opportunity for sexual violence and abuse. And I mean, I've heard Maria Cahill tell her story, and it's a very striking story, and the struggle to be heard, for people to acknowledge what had been done to her, and the consequences of that. And I'm glad that you've picked that up as one of your cases. I just feel that is where part of our role is overseeing historical institutional abuse, children and adults, and I just feel there's a massive story there which isn't been told. Clerical abuse in religious institutions, Borstal, this has been highlighted, but particularly from within paramilitary groups and the power that they had in communities and the power of silence over people. I just feel this is something which has not had enough recognition. And Kenny, you made the point about prescribed organisations not dipping into their pockets for the compensation, and they're prescribed, they're legal organisations, but I think the question should still be asked, you know, and they're part of wider movements. Why are these organisations not being pursued in some way to contribute to the cost of the consequences of their actions? I do want to, in terms of a question, I want to ask you, Kenny, I mean, with a year and a bit left of the scheme, and as it currently stands, and you talked about the need to do a mapping exercise, and you highlighted the low numbers coming from people outside Northern Ireland, and when we think in Operation Banner, 300,000 people serving in the regular army here in Northern Ireland. Are there particular areas you feel are underrepresented in the applications, and have you any suggestions for what should be done to address those?
Thank you, Brian, for the question. And I suppose, look, what I'm going to share is more anecdotal, because until there is an actual mapping exercise done, it's very, very difficult to stand over any of this. But certainly, from the perspective of, there will be some sense that in the northwest region of Northern Ireland, that applications are lower than they should be, given the gravity of what occurred, particularly in the capital city in that region. There would also be a sense that within the prison service fraternity, that applications are limited. Outside of Northern Ireland, there obviously are less than 1,000 applications at this stage, which I think needs close examination. And I do take the point as well that across our community, in working class communities, there needs to be an examination and a drill down as well around what's going on there also. So there is, without question, there are areas where there is a wider knowledge base around all of this. Access is perhaps easier for people to get that support, but I think there also is a redoubling of efforts here needed. And can I say this with respect? There are some MLAs who are very well over these issues and who are referring people from their offices into our support services. And perhaps there's an education process for other MLAs also within this chamber around this scheme, and to deal with some of the misnomers that exist. Because often there can be a circumstance where people are ineligible themselves for a financial payment whilst meeting the eligibility of the scheme, but the 10 years after payment to the next of kin stroke carer is something which is quite distinct to this scheme. And a lot of people, when they leave this life, want to know that they're provided for their families, and that's something that's really positive about this scheme in my view. So I think when I say mapping, not talking about spending 3-6 months doing this. It has to be a focused piece of work and done relatively quickly, or we risk JRs being taken in the future period from people who will make a very, very justifiable argument that they had no means of knowing this scheme existed in order to have a choice whether to opt in or not.
Okay.
Thank you.
Thank you.
Then we want to respond to the issue around the sexual abuse of women. Yeah. I think that's...
Thank you for that, and appreciate you drawing attention to that part. But I think that what you're saying really highlights a number of things. The lack of definition of what our experience of conflict-related sexual violence has been. We did do some information sessions at the very, very beginning of the scheme where we explored that a bit with the academic Dr. Aisling Swain, who's done an enormous amount of work around it. And it also shows how problematic the legislation can be. So sexual violence is experienced in the public and private spheres, whether whether they were in the interrogation centres or in the prisons, or whether they were in the private spheres, often by non-state actors as well. And so if we don't have a definition or an understanding of that, resulting silences and invisibilities and hiding of those experiences become compounded, and actually speaks to our wider discussion about how long the scheme should last. Because if we do come to a stage where we maybe join up this discussion with the discussions around Security Council Resolution 1325 and its implementation, or the Violence Against Women and Girls strategy, then, you know, our understanding of how it's been experienced and how we can provide remedy will be expanded. And those people, both women and men who experience conflict-related sexual violence in that range of settings, will become visible and perhaps become potential applicants. And it also speaks a little bit to the idea of, if somebody, for instance, was in prison when they experienced the conflict-related sexual violence, then, you know, they haven't been injured at their own hand. So things become a little bit more engaged, and we need to deal with the complexity of how the conflict was experienced.
Okay, thank you. That's very comprehensive. Timothy, please.
Thank you very much. Thank you very much for coming along today. It's been very helpful. I suppose I want to start off on the positive, that the feedback I'm getting from victims would be that staff are always very helpful, whether it's within the referring organisation or within the VSS scheme. They're very kind, courteous, and take the people through. The problem is the process, the time delays, the constraints that they're working in, and that's where it seems to be the re-traumatising continuously happens. But I do want to address a point, Chair. It was your first question regarding reconciliation, and I think the elephant in the room that we need to consider is, you know, this scheme is to help with reconciliation, but when we look at our system of government, when we look at our First Minister, who lauds victim makers, says there was no alternative, that is a massive part of re-traumatising victims. I think in my own constituency, Thomas McElwee, responsible for the firebombing attack in Ballymena in 1976, where Yvonne Dunlop lost her life, and on a tribute that Sinn Féin made, they said he was kind and good-natured, full of life, as well as brave. I certainly wouldn't agree with that definition. And while we have that re-traumatising going on from the head of our government, from the head of the executive, reconciliation will never happen in Northern Ireland. But going on to some of the points that I wish to raise, from the Innocent Victims Day that was hosting this building back in March, one of the things that continuously came out of the stories was this issue regarding the bereaved. Yes, the family member might not have seen the person who was killed, but that didn't stop their world being turned upside down. I'm thinking of one story in particular, where the father was out doing a day's work, was murdered. The daughter then, obviously the mum was at home looking after the kids. She had to then become the breadwinner. Not one, but two, but potentially three jobs. So that daughter lost her father in the terrorist atrocity and the terrorist attack, but also lost time with her mother because her mother had to fulfil that role. And there definitely needs to be something done with the bereaved, and I would agree with the calls that we do need to look at a separate scheme, but that scheme needs to be focused on those that are bereaved, you know, the innocent victims. It can't be perpetrators. You cannot lump perpetrators and innocent victims together. That's part of the reconciliation piece. That will never work within Northern Ireland. So picking up on the time delays, Kenny, or moving on, you talked about, was it either 60 or 66 to 70% of cases have been successful. So that's still potentially 30% of the cases that you've dealt with haven't met the criteria. Is that because of poor records, or what's the overwhelming theme coming out of that? I have a story in the office where a lady who worked, she worked in the solicitor's office at the time. She was blew up in a bomb. She was buried alive, left with scars, left with PTSD all her life. Knew the importance of record keeping, but it still took her 2 years and 9 months to get through the process. And I'm wondering, as part of the problem, so that was somebody that had all the records, had all the evidence, and it still took 2 years and 9 months. I'm wondering, is that 30% of people, is that because they haven't kept the information, haven't been able to get historic records from doctors, from medical professionals, or what is the overriding problems you're seeing with people being turned down? And that's something to each of the organisations. If you give us a flavour of percentage-wise of whose of applications have been accepted, and the ones that haven't, I want to know, the themes coming out of why they haven't been accepted.
Go ahead, Kenny. Go first, please. Thanks.
Thanks, Chair. I wouldn't have the precise figure in front of me in terms of how that breaks down, but certainly my sense is that it wouldn't be far away from being 50-50, in the sense that there are people whom don't meet the eligibility of the scheme as per how the regulations are written, and will not be eligible on that basis. However unfair any of us may feel that is, but they won't on the basis of what's there. And the other cohort of people, absolutely, there are issues around, particularly the non-digitising of records back in the 70s and even into the early 80s, where there was not a history of people going to see their GP. There were cultural reasons with that as well, depending on where people lived, their comfortability by going to particular primary care providers, and all of that. So there's a mixed bag, Tony, and some people as well, I suppose, have not had a history over the years of presenting to counselling. Counselling wasn't available as it is today. In the 70s and 80s, many people simply bit that bottom lip very hard, and they tried to do their best in getting through life as best they could. They often turned to a member of the clergy if they were of a faith background, or they turned to their own colleagues and friends, and sometimes they took to the bottle. Sometimes they took to other means to get through. So there is a mixed reason why that percentage isn't even higher than 70%. But certainly of those that we can put our very best case forward, I have confidence in our team to deliver good outcomes, even though the process could absolutely be better.
Okay, David, do you want to answer that one as well, please?
Yeah, of course. I suppose in terms of positive outcomes, we were similar to Kenny. I haven't got a specific percentage in front of me, but we have a very high success rate in terms of positive outcomes regarding the applications. There are those that haven't been successful at this point. There are issues, I suppose, to the eligibility issue, and even maybe in some instances a percentage of the disablement measurement that's taken into consideration. But there are reasons for that, and Kenny's outlined some of them there. For instance, that during particularly the earlier part of the Troubles, that people just really felt they had to get on with things. They didn't go and seek that support at the time, and even to this very day, I could give numerous examples where people are showing a very clear impact, a really very real trauma as a result of what they went through as a result of that incident, the Troubles, but have never felt I suppose confident enough to go and seek that support, particularly things like counselling, for instance. I suppose when somebody's going through that process, that's a very, very difficult process for them. They're reliving what happened, talking about that experience. Not sometimes people feel like it set them back rather than taking them forward. So there are numerous reasons as to why that could happen. So I certainly feel, I'm certainly, like Kenny, I'm confident in the work that we're doing, and certainly as time went on, we became more experienced with the scheme. We certainly feel we're putting a good application together for anybody that we provide support to. But there are, I suppose, issues just that if information is difficult to retrieve, that doesn't help any applicant in terms of supporting the evidence that we're providing, and it may be at times because they didn't seek that support at the time over the years that have passed, or that it just isn't the records on occasions. And sometimes it's very clear that people are at the scenes of incidents, and sometimes we feel maybe they're having to go that extra mile all the time to proving that if there isn't a particular record. As Kenny maybe I think outlined earlier on, if somebody's been told they weren't there, it almost made them feel like that they're not telling the truth. And that, how does that make anybody feel as well? So there are various issues for people not being successful. I think the eligibility and obviously disablement rate, because there is a 14% threshold that has to be met before anybody can receive any sort of payment. But there are issues that we see on a regular enough basis on anybody that gets a negative outcome.
Thank you, David. Sandra, please.
I suppose I want to pick up on a few points. Mr. Gasson, the thing around reconciliation for the scheme was reconciliation was never in the terms of reference. It's very much around the fact that people had outlived, for example, people who were very severely injured had outlived their compensation. Thankfully, they may have only been compensated for 20 years. They're now 60, 70 plus, and they're living with that dearth in relation to resource, in relation to the permanent disablement they've suffered. And I think it's really important to distinguish that, because that's what this scheme was about. It was that permanent disablement. And where people have difficulties, there's lots of difficulties. There's recognition of age. 1 to 3 is not recognised. Yet Siobhan O'Neill, our health champion, would say those are the most formative years in relation to trauma and the impact of trauma. And the same applies, of course, to HIA. We're not, 0 to 3 is not recognised. And I think that is a big issue in relation to this scheme, that lack of recognition. Also proven why you were injured, because the terms of reference are very, so because you're shot, people will automatically leave. Well, of course, why would, paramilitaries were in the community, or I was shot, and then you have to demonstrate what is the reason for that. And so mistaken identity, if the mistaken identity, you were shot in mistaken identity for somebody else, the reason why they were going to be shot comes into the issue in relation to how your case is looked at. The other thing is continuous trauma. There are very clear issues that rest within the scheme in relation to recognition of continuous trauma. They disappeared, something that's very close to the work we do, not recognised, and yet I would argue psychologically that's one of the most devastating, distressing events any family can come through. But if they didn't recognise the abduction, they're not recognised. And in fact, the issue around that continuous trauma is not recognised even when they did see the abduction, because it's the reality of what those families have gone through the years. So that continuous impact when people are living within communities where violence is ongoing, that they don't ever really escape what happened to them because it's ongoing, and other things can happen to their family in that period of time. Proving proximity is another issue. And I think that also causes difficulties in relation to individuals. And I suppose it's around the presentation. I can see a very detrimental impact for women, particularly women who kept their families together, who went through very difficult times, and who worked their whole time. But by God, they struggled in relation to that work and to hold their families together, and where that actually can have, impact in relation to degrees of disablement. So I think there are very clear reasons, and I think that the 0 to 3 is an issue that is consistent across other areas of work that you're looking at. And I think cognizance needs to be taken of Siobhan O'Neill as health champion in relation to what she has indicated in relation to how that's formative in relation to how people are today.
Okay, thank you. Andre, do you like to? Go ahead.
No problem. Just to pick up on your first point about no medical evidence, we're finding that a lot, and it's not necessarily why people are turned down, but they're being referred to psychological assessments, and then they're being referred back to CAPITA. So that's then, and then they basically go through an audit process, and this has taken several years of that application process, which is re-traumatising for applicants, where they're having to relive the incident, and being asked intrusive questions on several occasions. But in terms of why we're finding maybe people are being turned down, again, we don't have the exact figures, but it would be kind of similar around eligibility. So where the panels are saying it's not troubles related, or also the bereaved, as was mentioned, aren't at the scene or in the immediate aftermath, and then maybe where they were in the immediate aftermath, they're being disbelieved. So very often there's accounts, often the state or the RUC's accounts are then used against them, and then they're said, can you explain the discrepancies and how you remember how your loved one passed away? So all these and that's basically used then to make someone ineligible. So it's all around that kind of criteria around the TRI and the immediate aftermath that we're finding.
Okay, thank you. Anya, please.
Thank you, Chair, and thank you everyone for coming in and joining with us and briefing us today. My first question is for Rory and remarks that he made during his opening remarks, in relation to victims of plastic bullets and rubber bullets. Rory, how would you suggest, I suppose, that the conflict inversion of events between victims and state actors is addressed?
So I think just to remember that it's a victim-centred approach, and to believe victims, and obviously there's sensitivities around that Regulation 6.1, but it's where there's, in this case, which is what there's strong arguments to suggest that the conviction was unsafe, there was more, accounts given to the panel to show them. And in this instance, the panel turned to the victim and said, we understand you, but we're bound by this regulation. And it's I guess it's not taking a rigid approach and just remembering, it's a victim-centred process, and they should be at the centre of the process.
Again, holistically as well. No, look, thank you, Rory. And I suppose my second question is for everyone. And you've actually touched on it in your response to Timothy there, Rory. Capita. What is your experience of victims that are going through assessments with Capita? Are they trauma informed? Do they take a holistic approach with victims? And I suppose, is there room for improvement?
I think that it depends who you get, right? Very often, we've had really positive experiences from some assessors, but we've also had negative. But it's mainly structural that creates this. So the routine, asking to see people who've suffered head injuries, having to see scars for women who maybe suffered the head injury many, many years ago and having their hair, asked to remove wigs, and other forms of scarring. When there's clear medical evidence, it's just there in black and white. There's no need to bring the person in and ask them to get down to their boxers to show off scars. No need at all. And right the way through to psychological assessments where if a person hasn't, for lots of really good reasons, and this is really gendered, where women were terrified of seeking medical assistance during the conflict if they were suffering from psychological injury, that their children would be taken off them. So they didn't seek assistance during those years, and now they're going to the psychological assessment for this scheme, and that can be a really upsetting, re-traumatising experience, particularly because they are asked not just about function, but to relive the harm that they endured, and that was really difficult. To speak to some of what Rory spoke about there, one of the strong elements around being disbelieved is if you were affected by a plastic bullet injury, very often you didn't go to the hospital because the RUC was there arresting people in order to justify the use of plastic bullets at the time. Or if a person then went for civil proceedings, then they were arrested and charged with riotous behaviour or whatever. How the conflict was experienced in different areas is something that we all know and we all recognise, but the scheme doesn't. There's a default position of believing the first comprehensive report that was written, that was inevitably by the state. And if you were affected by state harms or later on, then that could be something that will really impact on your progress.
Right, thank you. David, do you want to take that one, please?
Yeah, certainly. Thanks, Chair. Chair, I suppose at the beginning of this process, there would have been obviously a fear about going through these processes, particularly in terms of Capita, because of the bad press, the perception that they would have been around, for instance, the PIP process, as an example. And whilst I would dearly wish that applicants didn't have to go through these processes to try and prove a disability, I can genuinely say that I found so far the approach to be a fairly positive experience. And whilst it's a difficult process for the applicant to go through in terms of obviously talking about the condition that they have, talking about the trauma that they've experienced, relaying the detail of the incident that they were involved in, I would say that those that have been carrying out the assessments, and again, I'm speaking from our experience as an organisation, and my colleagues could obviously comment on this as well, we have found the approach to be professional and to be compassionate in many instances, and certainly it's something I welcome. I would also say that Capita do engage with us on a regular basis, and we have contacts within Capita that if we did have any concerns about a particular assessment or anything that we felt wasn't appropriate, we have those channels to raise those concerns. But I couldn't genuinely sit here today and say that everybody's receiving a bad experience or not. From our point of view, it's not easy, and we have to be there to support our clients and the applicants after those processes to make sure that their welfare has been looked after. But certainly from the approach that has been taken so far, we've found it a more positive experience than not.
Okay, thank you. Right, Kenny, please.
Thanks, Chair. Not to reiterate what others have said, but I think again with Capita, and I want to say, to be fair to VPB and indeed to VSS and TO and DOJ are all involved in this. There's some really good focused sessions that have been offered over the period of time of this scheme, where we've all come together to discuss a range of issues. And in many of those circumstances, there's been workable workarounds for particular issues that have been raised. So there has been a willingness to try to do what they could. And sometimes people will say, well, that's on the margins. Maybe the issues, the systemic issues, haven't been able to be moved. But there has certainly been an effort on the part of people to do what they could. I suppose what I would say as well with Capita, that in many ways you're getting an experience or hearing today from groups whom are supporting victims and survivors through the process, and we account for something like 60 to 70% of what's come in. I think maybe 70 at this stage, but 30% of people who have applied themselves do not have the support of a group. They don't have the option of having someone sitting with them through those range of assessments. And it's actually that constituency whom could have an even more difficult experience than that which has been relayed to you today through our groups. But we have to try and do as much as we can to be with people throughout the process. It's not simply about submitting an application, waiting for an outcome and then appealing if it's required. It's about being with them at all phases throughout. And just to say as well today that the services, the pressures that we have had across our organisations around our health and wellbeing orientated services, counselling, the whole plethora of other services as a result of this scheme, that also needs to be acknowledged. People whom were previously unknown to the victim survivor sector are now coming in, being supported, and then want and need to require the other support services.
Thank you. Go ahead.
Chair, sorry, if I could just come in on that, just to support Kenny on that comment. I don't think probably any of us, really envisage the impact it would have on all of our services as organisations, and we're seeing that as well. That there's that practical support that's needed. We obviously support the clients right through the application journey, but that has placed, obviously significant pressure on the other resources that we have as organisations. So it's just to confirm that.
Okay.
What Kenny's already mentioned.
Thank you, David. Go ahead, Sandra, please.
Well, I think at the very, very outset, Justice McAlin led the way by getting trauma training, trauma education into the Victims Programme Board. And based on that, there was a ripple effect of that being viewed in relation to having every cohort go through. So I have a disclaimer, and we engage in trauma education with Capita. Each cohort comes through. I think and actually Kenny had highlighted it, as he said at one of the sessions, or maybe it was David, there was a big question around the sensitivity of known language, and it was more around the sensitivity to the nuances in relation to the troubles, in relation to the acronyms. And so Capita responded and have engaged now in a sensitivity session really about having a better awareness of the acronyms used here and in relation to the context of the troubles. I think there's a number of things. One is that the wraparound service is really important. It's really important to have a victim-informed approach, and we would hope that's what they demonstrate. But regardless of how victim and survivor informed it is, it's still traumatic, and there's no point saying anything different when people are taken back into that. And I do think in relation to TEOs, I suppose providing additional money in relation to the wraparound service to ensure there are individuals working in relation to families, working in relation to support is really important, but there's an adverse impact, there's no doubt, in relation to services on beyond that. And I think probably that's not maybe what was foreseen at the very start, would be the sheer level of referrals coming through, but the fact of when you start, it's not just one person off within a family. You may get 3 or 4 or more without the family. So I think that victim-centred approach is essential.
Okay, thank you. Sinead, go ahead, please.
Thank you, and thank you everybody for your evidence today, and thank you for the work that you do every single day in supporting victims and survivors. There's been lots of questions asked, so it's really just two short questions. We've talked about the need to ensure that applications are processed quickly, and you've alluded to that in your answers. But what would you say is needed in order to make sure that there is speed in the process. Is it more a significant uplift in resources, or is it more than that?
Okay, go ahead, please, Andre.
I suppose that's more a question for the VPP than it is for us, to be honest. You know, we certainly, in terms of us being able to support someone who initially makes a call today for support, they are going to have to wait a considerable amount of time in order to be able to get a caseworker, to be able to work with them, to make the application at all. And that period can involve evidence gathering by the applicant, and it can be simple paperwork as well, in order to make that a little bit more expeditious. But, you know, if you're phoning today because you've just found out about it, you're not going to get a result to this, you know, for at least 3 years. It's going to be a long, long time. So this is a long journey that probably people don't understand and don't experience elsewhere in their lives. And, you know, I think, you know, some of it is resources, some of it is the process. Yeah, it's not easy, Sinead.
Well, maybe hold that question for the next panel then. What's your second question, please, Sinead?
And the second question is just from the organisation's perspective, how responsive has TEO been to your concerns in this mandate since the Assembly was restored?
Go ahead, Sandra, do you want to answer that one?
Yeah, I mean, I think that TEO has been responsive in relation to ensuring that resources were put in to groups in relation to providing assistance to individuals. I think there has been attention given in relation to the need for that wraparound service. As Kenny said, you know, for people going through on their own, it's a very daunting experience, and actually we get a lot of appeals from people who did their own form. And subsequently then that has been problematic for them, and then we picked them up at appeal. And by that stage, you know, they've already had a very long wait and a further wait to come. So I think that TEO have responded. I think the difficulty, from and this committee maybe could look at it, is forecasting through, because to be quite truthful, the scheme may finish within the next year, or in terms of from a timeline. The question is, should it not? I would argue, like Kenny, that there hasn't been enough due diligence in relation to outside the north, outside Northern Ireland, and there are people who do not know that the scheme exists that are eligible for it. So I think that there needs to be a very clear communication strategy and a very big push, and not right to the wire, that it needs to be as early as possible. And whatever needs to be done to get people through that scheme. But for TEO, there also needs to be a very clear look in relation to mapping out what does that mean for service provision, because holding budgets, I mean, most of the groups, in fact all the groups, are in budgets in 2016, and the reality is there's an impact of that in relation to the sheer volume of work coming through.
I'm going to...
Okay, thank you very much, that was very helpful.
I'm going to actually...
Very briefly, and I think the right person to ask is Sandra in this question. You made an interesting comment with regards to the impact on people in their early years. What evidence is there that there is late onset trauma for older adults who perhaps only today are starting to realise the impact of something that happened 30, 40 years ago?
Okay, I'm not going to ask you to answer that, but if you have any links or any information you could share with the committee, just conscious we've got 2 more panels, and we actually are about 40 minutes over schedule in this one. So any information that any of the panel members could have in that regard, we'd really appreciate it. So thank you all. There was quite a lot we got through there. Really appreciate that. So. Committee members, or you can take a 5-minute comfort break then, and then we'll get started at 25 to. Okay. Okay.
Thank you, Chair Team.
Okay, that's okay. So we'll ask Andrew.
That's everyone out.
Committee Room 30, sound. Committee Room 30, sound. Committee Room 30, sound. Committee Room 30, sound. Committee Room 30. 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 Sound. Committee Room 30, 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 Sound.
Okay, members, we're coming back after a short break there, so we're going to move on to our next panel session, and this is around the Victims Payment Board and officials from the Executive Office. Brian, had you got a suggestion?
Yeah, I mean, on our agenda, as you say, we have the VSS coming in and also departmental officials. We had planned 2 separate briefings. I feel we'll be asking similar questions of both. So, suggestions that we combine those as one panel.
Okay, is everybody in agreement?
Agreed.
Okay. Okay, so members, I'm going to refer you to pages 78 to 79 of your pack for the clerk's brief, pages 10 to 13 of the table pack for the briefing paper from the department, and as per the agreement there, we are going to have a panel that consists of the Honourable Mr Justice McAlinden, who's the President of the Victims Payments Board, Mr Paul Bulick of the Victims Payments Board, he's Secretary, Mr Patrick Gallagher who's the Director of Victims and Survivors of the Executive Office, and then Andrew Walker, who's the Chief Executive Officer of the Victims and Survivors Service. So thank you all, gentlemen. Apologies, you'll have seen how much ground we covered in that last session, so apologies we're starting late. But if we can maybe start with the Victims Payment Board themselves. You want to make some introductory remarks, please?
Right. Well, members of the committee, I'm very glad to be here with my team to, first of all, listen to the views expressed by the victim support groups, which I found, as always, very helpful, very informative. And I have to say that the board and the victim support groups, I think, have a very good working relationship, and we value their input very highly. In fact, the board couldn't function without the support groups. So it's always good to regularly meet them, which we do, and it's always good to hear from them in the context of giving evidence before this committee, because, you know, in face-to-face meetings they might be slightly reluctant about, let's say, expressing their views as forcefully as they have done today. There's a couple of things that I want to really pick up. I think it's important that I do. In terms of phrases such as dehumanising, cruel, re-traumatising, non-victim centric, victims being undervalued, and ritual humiliation, that's not the scheme that I'm administering, and it's not features of the scheme that I accept or I consider are appropriate comments in the context of this scheme. This scheme is a victim-centric scheme. This scheme has been set up with a view, with me as the president of the scheme, to ensure that harm is recognised, and to ensure that through the recognition of harm and the payment of the making of payments to victims, that does, in some way or other, maybe to a limited extent, but to some way or other, strive to achieve some form of reconciliation and healing. Those are the fundamental tenets of the scheme, and those are the ethos. The ethos of the scheme is geared towards the achievement of those fundamental tenets, and it's the message that I've driven home, both to board members, to staff of the board, and also to Capita, that we must never lose sight of the fact that this is a victim-centric scheme. It is to try to recognise the harm and hurt that was caused through the Troubles. It is to try to provide financial support for those suffering from permanent disablement as a result of the hurt, harm they suffered during the Troubles, and through those mechanisms, those limited mechanisms, to provide some form of reconciliation. Now, there are shortcomings in the scheme. Those shortcomings were readily apparent to me when I took on the role as president of the scheme. The major shortcoming that I have always felt is a troubling feature is the lack of recognition in respect of the bereaved. They are a section of those directly affected by the Troubles that are still left outside the scope of a bespoke scheme. You have to look at what is included in this scheme to understand the issues about the bereaved. A person is entitled to payments under the scheme if they suffer an injury which was caused by a Troubles-related incident, when they are present at the Troubles-related incident, or in the immediate aftermath. Now, it's not in terms of appreciation of a deceased loved one. It's about being present at a Troubles-related incident or in the immediate aftermath. Now, that is quite limited. In essence, they have to show that they suffered an injury as a result of being the victim or coming upon the scene of a Troubles-related incident in the immediate aftermath where one of their loved ones was injured or killed, right? That is a very restrictive definition of entitlement. What the scheme has done, okay, and through the guidance that's been given, we've tried to extend that as far back as possible. In other words, the immediate aftermath, we have said, well, look, if the deceased is in the same condition, hasn't been, let's say, tidied up, cleaned up, manipulated by way of medical treatment, etc., etc., if the deceased is in the same condition as would have been the case when injured or killed, then, you know, we'll try and squeeze you into the scheme. So in essence, what Relatives for Justice are saying is this dehumanising approach to the bereaved. What we're trying to do is manipulate the very limited structural boundaries of this scheme to try and deal with as many people as we legitimately can without doing utter violence to the language of the scheme. So I utterly reject the issue that we are in some way dehumanising applicants who come before us. What we are doing, or what we are trying to do, is to stretch the boundaries of this limited scheme to ensure that the clear deficiency and deficit, the absence of a scheme bespoke for the bereaved, does not have as hard an edged, damaging impact as it otherwise would. Okay? So we are making our very best to try and expand the scheme rather than narrow the scheme. Now, another comment was made about the default position as to who to believe. Absolute and arrant nonsense. Okay? We have to, under the terms of the scheme, determine that a person has been the subject of a troubles-related incident that has caused injury and that has resulted in permanent disability. That is an evidential fact-finding process. It's not about adopting a default position. The fact that we welcome applicants to come before panels to give evidence is to allow them to put their best foot forward, so that if there's an argument to be had between a historic record on one side and a panel listening to a credible applicant giving evidence on the other side, the panel is going to accept the credible, reliable evidence of that applicant given face to face. So there is no default position in respect of who's believed and who's not. The third point I want to make is the statement that was made that there is absolutely no need to assess people in respect of scarring. That's arrant nonsense. As a personal injuries lawyer who's worked all his life dealing with people who are severely injured, as a judge who has assessed very severely injured individuals in respect of physical injury regarding scarring, and as president of this panel, I can tell you that the best way to fully appreciate the impact of scarring is to see it, okay? To look at that person and to see the importance of that scarring, how they view it, how they've been affected by it. You cannot pick that up from a diagram. You cannot pick that up from a photograph. You have to see it. Now, in terms of the protection of individuals going through this scheme, if they don't wish the panel to see their scar, if they don't wish the disability assessor to see their scar, they don't have to show it, okay? But they're invited to do so on the basis that that gives them the best opportunity to demonstrate the level of injury that they have suffered. So it's not about dehumanising, it's not about being cruel and re-traumatising, it's not about being non-victim centric, it's the exact opposite. It's about trying to give individual victims the very best opportunity to demonstrate to the panel, to the board, that A, they're entitled, and B, the nature, extent and duration of their disability. So this scheme, it may take time through various applications to be dealt with. The time that's taken in relation to applications is a factor and a function of the care that's taken, not to exclude people, but to ensure that everybody that is possibly entitled gets a payment.
Okay, we'll leave
So,
yes, no, I just wanted opening remarks.
Yes,
I appreciate.
Those are the opening remarks
Okay.
that I wish to make, because it's important now.
And
One
you've put them
further
on the
thing.
record. Justice
The bit about the extension of the scheme, right?
We will get back to that. We will
Okay.
get back to that. Go ahead, please, Patrick, if you want to make some opening remarks. In terms of your...
Mine was very much just around setting out as in the paper, the rules between the TO and the Victims Payment Board. So as you've heard from Justice McAlinden, the board has that operational responsibility. TO's responsibility is around the policy and the funding. And the key element that we have is the support services, which you've heard from the groups previously, that we fund the support services over 7 million to date on ensuring that there's welfare officers and admin support to help people with their applications, keep under constant review the needs. We've also added in health and wellbeing because we recognise the wider impact that was spoken about in the earlier panel, that there's more funding that's been provided in recent years to increase the health and wellbeing support linked to the scheme. Another key element that TO have responsibility is the evidence partners. So linked to the evidence that the board need to be able to assess an application, we have arrangements in place that we fund PRONI, the PSNI, work with the Ministry of Defence and anyone else, the Health Service, to make sure that people are resourced there and teams are resourced to go and get the evidence that's needed to support the applications. So just, the figures were in the paper that was provided, but they're obviously keep improving and keep going up, and we're over 90 million now, has been paid out since the start of the scheme. We appreciate there have been concerns around the delays, but I think if you look at the ongoing year-on-year number that's gone out, 3 years ago it was 14 million, 2 years ago 24 million was paid out, and last year was 46 million. So there has been that continued rise, which we hope and expect will keep going to make sure people get what they deserve.
Okay, so you've just touched on some statistics. We'll maybe come back to that in a question. Would you like to make some opening remarks, Andrew, please?
I suppose we've slightly changed the dynamic now in terms of merging the two panels, so I did have some opening remarks, but I'm quite happy to feed into the questions if that's preferable, just in terms of time. But I think you've heard a little bit about VSS role already in terms of the support for the organisations that you heard from this morning, so maybe I'll just feed in if that comes up during the questions.
I appreciate your indulgence in that regard. Okay, coming back to yourself, Justice McAlinden. So, in terms of, to what degree do you feel that there's an impediment to the process without having an external or a different appeals layer to this?
Well, you have 70 board members. The 70 board members then make up these panels. We have regular training sessions to ensure that there's consistency of decision making, but I have to accept there are some examples of inconsistent decision making which then are referred to me. There is an appeal process. There's also an internal review process where I can direct that a decision be looked at again by a different panel on the basis I am concerned about the outcome. So there's this internal, let's say, review and appeal. The next level is the judicial review option, which is available to applicants who feel that the scheme or that the panel has not decided the case in accordance with the regulations, or has otherwise failed to comply with fair process or whatever. So we have experienced a number of judicial review applications. There is actually one judicial review application ongoing at present about the definition of a troubles-related incident and an injury flowing from that, which relates to punishment shootings. So that issue, which we understand is an issue that Relatives for Justice and others have raised, that is a matter which has already gone to the High Court. Mr. Justice Schofield has heard the case and has reserved his decision on that. So we can, I don't think this idea of another external layer of appeal is either warranted, cost-effective, or necessary. There is the internal appeal process, the internal review process, and there's the option of judicial review. And all those options have been exercised to date. The appeal process, I think, has in general ensured inconsistent decision-making is remedied. Okay? Now, we wish that there wasn't inconsistent decision-making. there is, simply because you're dealing with panels made up of 70 different individuals, etc. You're bound to get some inconsistency. There's a database of decisions that's available to all members of the board so that they can consider how other panels have decided similar cases and ensure consistency. So we're doing all that we can in respect of that, but I don't believe that an external appeal mechanism short of judicial review is needed.
Okay, thank you. And the other question I want to pick up on is in terms of the time taken to process applications, and I think you'd indicated there that in many ways it's taken so long because you're trying to get the right decision. So if you could maybe speak to that, and if there's anything in terms of TO support, Department of Justice or otherwise that could...
Look, there's a number of issues there. First of all, a lot of these applications relate to very old events, okay? Documentation is limited. You have to do a bit of digging if there's, let's say, a paucity of evidence in relation to the application that's brought. There's a difference in quality between applications brought by individuals and applications brought with the help of the support groups. A very big difference, okay? And you find that the applications brought without support groups, there's a lot more digging that the board has to do in order to try and get the evidence. Now, the way the scheme is set up, the applicant has to persuade the board on the balance of probabilities that they are entitled, okay? We could turn around and we could say, look, your form is defective, you haven't shown your case is out. We haven't done that. What we've done is we've set up all these mechanisms inside the scheme to try and build a case for them. In other words, we go and we ask all the various agencies that were in place at the time, what's your documentation in relation to this incident? Police, MOD, etc., fire service, etc., etc. And then we go along and we say to the healthcare providers, what's your documentation in relation to this individual? GPs, etc. Now, we have various memoranda of understanding with all these various bodies saying, please give us your information. We can't compel them to give the information. We ask them to, okay? And the government has helped in terms of providing funding to these various bodies to enable them to staff up to provide the information to us, so that, you know, the regional health board, etc., they have got some funding to feed down into the various healthcare bodies to give us the information. But we have to maintain working relationships with those various entities. We cannot go, let's say, in both feet forward, trying to, pressurize them to do more, etc., etc. It's all about maintaining good working relationships with various statutory agencies to get the information. So, information retrieval takes a long time, okay? A lot of these cases are psychological harm cases. A lot of these cases go back to a time when diagnoses were not basically common, okay? So what we have to do then is, in the absence of a diagnosis, because we have to show that there's a troubles-related injury, okay, leading to disability, we then had to set up a bespoke mechanism to provide us with definitive diagnoses in terms of applicants' injuries. That meant that we had to request the help from a body of psychiatrists and psychologists and other healthcare professionals to examine these people now, to examine their records, and to give us a diagnosis so that we can, categorise that as an injury giving rise to disability. That takes time. The funding of that whole process, again, took time to get set up, and through the great work of the Regional Trauma Network with Dr. Kieran Mulholland, we have that set up now. So that's another factor that takes into that causes delay. Another thing that causes delay is the many of these applications relate to many troubles-related incidents. Each one has to be looked at. Have to verify each one, have to verify presence at each one, and then we have to verify that each one has contributed to the injury that was suffered in this case. And then we have to get the final aspect of the case, which is the disability assessment, which is capita assessment of the applicant, either on paper or through an interview over the phone or through a face-to-face. All that takes time. All that takes time. And that's why rather than pushing through applications speedily and seeing much higher refusal rates because the evidence is insufficient, we're taking our time, doing all the digging, trying to make sure that everyone that is possibly entitled under this scheme gets due recognition.
Okay, thank you. Go ahead, please, Andrew.
Just make a comment tangentially to that around the timelines and the appeals. And that one thing that is clear, I suppose, from the session this morning and what we've just heard is that whilst the scheme may come to an end for applications in August 2026, there will be a tail here, there will be a need for that continued support. And the benefit of having that support within the community and voluntary sector is that it helps people all the way through that journey. So there has been ongoing conversations with the Executive Office to ensure that funding for that support doesn't end in 2026, it continues on. And that support will be there in the community for people going forward. So I think that's just important when we're talking about the timelines and the extent.
Okay.
Chair, can I just come in just on the back of what Justice Michael Linton said? Just on the operational side of the House, where the administration team that we have, we invited innovation and consultancy services in last year to really look at our end-to-end processes. And they did identify some areas where we could make streamlining and reduce streamlined activities, make some improvements. So we have now appointed a project manager just over the last month, and there will be a project. So we will be looking at any areas where there will be duplication. We'll be focusing on communication with the applicants. Can we improve our communication touch points? We'll be focusing on maybe more upfront, bringing in more upfront analysis of gaps in the case, so we can maybe stop to and fro in cases. So we would hope, apart from what Justice Michael Linton has explained around the complexity, we do hope we could maybe make some improvements to the timeline. But it'll not be a massive quick fix, but it will be because we'll be processing these applications for years to come, even after the closing date for receiving applications. So that's a piece of work, and we would hope to be reporting on that over the coming months and year, that we can see improvements to the timeline for applicants.
And is there, just on that very quickly, will you be then engaging with previous applicants for some feedback from them in terms of?
Yes, and we'll be engaging with the groups as well.
Okay.
It'll be, we have a whole project plan. There's different strands. One of the other things, the big benefits will be, we don't have a case management system at the minute. We're acting with a portal with its own restrictions. Yeah. The case management system should do a lot of, should remove a lot of time out of the system, or out of different parts of the process. Yeah. So, but no, certainly we will be engaging with all relevant stakeholders as and when we can and need to.
Okay, thank you. Deputy Chair, please.
Chair, thank you. I have two questions, but I want to just go back to the last statement that's been made, that you don't have a case management system.
No, we have a case management portal, but when we were designing this scheme, we were designing it from scratch. This is a very unique scheme. There's no other scheme like it. There wasn't even anything else to compare it to. So when we had to start from scratch, we had to establish the board. We had to establish the administration team. Part of that was putting in our IT support. But we have a portal where people can put applications into. But there are gaps in that portal, so we do need a better case management system for MIR and for processing. Some of our work would be carried out on spreadsheets, and some of it would be manual as well. But there was such a demand to open the scheme by a particular date. We had to have something in place to allow it to open. Now, since then, we have made many improvements and enhancements to it, and I would say it's a good system, but there's room for improvement.
I have to express concern about that, Chair, particularly given the length of time the scheme has been open for, and I think that's an issue which the committee might want to return to, and perhaps invite the Northern Ireland Audit to examine that as a shortcoming. Can I address?
Can I just say, David, Chair, we have been audited recently on a number of the processes, and There was nothing of major concern that came out of the audit. You know, we have good, robust systems in place. We have three subcommittees on the structure of the board. We have a business assurance committee, who are looking at governance and risk and business planning, and then we have an operational committee. So our governance and accountability between the board and the executive office is very robust.
Just on the executive office point of view, we do have those arrangements to scrutinise the work of the board and to work through it. You know, I think in an ideal world a case management system would have been there at the start, but we have to remember this legislation was handed to us without any engagement with the departments or governments here, so there was not that time that you would have done if you developed your own legislation to plan. It was written and delivered at Westminster without engagement with the Northern Ireland Executive. Then, as Paul has talked about, the speed of turning this around. We know the age profile of victims and the needs of victims, that there's obviously that speed in that campaign to turn around as quickly as possible. Equally, a huge focus has been on increasing the rate of applications, which, as I said, has gone from 14 to 24 to 46 million. That has been an understandable and a reasonable priority, while ensuring that the governance is there. As Paul said, the audit office have been in and found no concerns or no major concerns, and we are happy with the scrutiny at the accountability meetings.
Chair, I don't want to delay this, and I hear what's being said, but I have serious alarm bells ringing that an organisation that's handling this amount of public money, and more importantly dealing with very vulnerable victims, doesn't seem to have a case management system. Can I reflect two questions to Justice McAlinden? Justice McAlinden, you heard today, and you've made reference to some of the frustrations, and I appreciate the remarks that you've made about some of the comments that were made, but I think broadly speaking there are some frustrations equally that have been made in respect of the scheme. And I think you've indicated that you have perhaps pushed out to the edges as best you can of what's in front of you. But what further support can you give within the limitations of the legislation as it currently stands? And I suppose as a supplementary to that, if you were writing the legislation, how would you do it?
Yeah, well, as a serving judge, I'm not supposed to comment on legislative matters, but as president of the Victims Payments Board, I feel quite happy to do so, right? We have a fundamental issue here, right? The whole issue of victimhood is a divisive issue within our society. And it is so divisive that the local elected representatives, the local executive, were unable to agree a scheme that facilitated all views in terms of victimhood. Okay? So we had Westminster take up the baton and in essence impose a scheme which I think no one is very happy with. Okay? First of all, the issue of the bereaved is a massively, I think, painful issue for many. I think in terms of where we are with the whole concept of a troubles-related incident, I mean, the definition is an act of violence or force by reason related to the constitutional status of Northern Ireland or the political or sectarian hostility. You have difficulties fitting in sexual violence within that, okay? I mean, you have to differentiate between the thuggish activities of paramilitaries and an act of violence for political ends, okay? You know, the two are not equated. Just because it was a paramilitary did something or something like that doesn't mean it was a troubles-related incident. So that is, you know, and I know that that's a matter of dispute, and I know that that will be part of the argument in terms of the judicial review about punishment, beatings, etc., etc. But we have quite a limited and narrow definition of a troubles-related incident, and we have quite a limited and narrow definition of victimhood, and we have the exclusion of the bereaved. Now, those are issues that locally this executive, this assembly could deal with if they could agree, okay? If they could bring their heads together, they could reconstruct this scheme to make sure that everyone that was injured, okay? Now, the issue about no fault, I mean, I fully appreciate that. You know, I fully appreciate that in terms of paying money to someone who was injured as a result of involvement in an act of violence themselves, that actually re-traumatizes the innocent victims. I know that, okay? So that's a really thorny issue, right? But there must be, with goodwill, okay? With your life experience, you all are, you know, products of this society. The key issue that we have to look to is, you know, we have to focus on the past to try and deal with legacy. We have to focus on the past to try and deal with the issue of victimhood, but we also have to try and move forward. Our society at present is trapped and caught, okay, because of our inability to move forward together, okay? And the absence of an ability to move forward together leaves vacuums where you still have paramilitary involvement. You still have paramilitary control of various sections of society. And that's because those disaffected individuals do not see the type of progress and working together in our executive and in our assembly that there should be. Okay? So in terms of this scheme is a microcosm of the problem that is societal. Okay? This scheme is a microcosm of the inability of people to recognize what went on in the past, recognize that there was fault on both sides, apologize and open up for the hurt and harm that they caused. And that's where I am very strongly of the view that this whole legacy process is so one-sided, because we have the state that has to open up and we have the paramilitaries that are basically keeping stone. Okay? That is unacceptable. Okay? If you want to move forward, everyone has to open up. Everyone has to open the book, and everyone has to apologize sincerely for the harm and hurt that they caused. Now, that's where this scheme attempts to give definition to the issue of reconciliation, because this scheme, even by its shortcomings, highlights the societal issues that we have to address as a society with a view to trying to move forward. And we have to move forward. Our youth need hope, okay? They need employment, they need decent health care, they need decent infrastructure. We cannot afford to focus so much on the past that we do not invest in the future. And to invest in the future and to have the ability to invest in the future, we have to finally deal with the past. We've been skirting around these issues for so long, we're not getting anywhere with them, and it is time that we did for the benefit of our children and their children, so that this place is actually worth living in, and this place is seen as a thriving, vibrant, economically self-sustaining entity. Okay, that's what we need to focus on, and that's where I think we're not achieving, and this scheme is just a microcosm of the difficulties that we have in society.
Thank you. I think the clear message coming from that is that we cannot ignore the past in order to take us into a better future.
Absolutely, absolutely. And this is all about trying to do our bit to try to give recognition, okay? And through that, giving recognition to lead to some form of reconciliation so that there's movement forward. But there are clear, as I said, clear deficiencies in this scheme. It's imposed by Westminster. It was quickly imposed by Westminster. And, you know, I'm inviting the Assembly, I'm inviting the Executive to take possession of it again, to create a scheme that is more rounded, more targeted towards dealing with the needs of our society, because as a group, the Assembly knows about the needs of our society. We have members from all different backgrounds, all different classes, all different creeds, etc., etc. They can all usefully bring their experience and understanding to trying to fill out this scheme, but also fill out the big project of dealing with the past so we can move forward. I mean, it's a massive task. Okay, it's not an easy task. I do not envy your role, but I implore you and urge you to use your best endeavours to do that.
Okay, thank you. I'm just going to move on. I might bring in the end. I've got time. Carol, please.
Thank you. Patrick, has there been any attempt to try and amend the scheme through local legislation?
No, the only legislative have been correcting errors through Westminster, but there's been no amends coming forward through local.
And is there any intention to, particularly in relation to the bereaved?
No, not this scheme. No, there's nothing come forward to amend the scheme. But the bereaved, there has been the paper from the most recent Commissioner of Victims and Survivors that the Executive Office then will be considering as part of the new strategy. So that makes recommendations around a scheme.
Will that be a different strategy, or
no, the strategy that I was here on previously? So that includes makes reference to that paper that Ian Jeffers delivered as one of his last weeks as Commissioner, that talks about his proposal for a new statutory scheme for the bereaved. But obviously that there would be a lot of consideration needs to go in before that comes forward, as well as then the political agreement and funding for something of that scale.
And in your opinion, would that close some of the gaps that have been identified by the groups?
I think that is what the likes of we have been engaging with us on, that's come up during the strategy, is that they have identified that, as the Justice McAlinden mentioned there, some people bereaved can get in, but only if they're in the immediate aftermath. But that leaves out, never mind those who came a bit later, those who just didn't see their loved one at all, who were bereaved of a spouse who might have been in a different country. They're left out of this scheme because the scheme, as initially agreed in Stormont House, was for those severely physically disabled, and then has been moved further on. But the proposal that CBS have would cover the majority of those. We can't say whether it would cover everybody.
Justice McAlinden, and maybe even yourself, Paul, it's in relation to the information that is given to help you make a decision. So you don't have any powers of compellability? None? Is that something you feel that you need?
Well, again, it would be helpful if you could demand medical records within 14 days, okay? The thing is that we know that puts an intolerable burden upon general practitioners. I mean, you try and get an appointment with your general practitioner, right?
Yeah.
Okay?
Yeah.
You ring up and you're lucky if you get a receptionist. So in essence, the system, there's a lot of systems teetering on the brink of crisis here, right? And so this idea of just introducing compellability, well, that really doesn't address the issue, because all you're doing is basically you're compelling them to do something, so they're going to redirect funding from something else to meet your request.
No,
so in essence,
I
it's funding. It's funding, and it's the same thing as the bereaved. Okay. I would say yes, the executive, First Minister, Deputy First Minister, they would probably introduce a scheme. Okay, but where's the money coming from? Because Westminster are probably going to say to them, well, actually, we're not giving you any more money, so if you want to, knock yourselves out, design the best scheme ever, but you're not getting any more dough for it, right? So, again, it's who pays. That's a thorny issue in terms of remedying the defects in this scheme, okay?
So can I just offer you an opinion?
Yes. I'm very glad to hear any opinion that...
Well, I mean, I think the British government, in my opinion, weren't, in the middle. They were here. There was a conflict. They were participants in that conflict, and they need to pay for that. The reason I'm asking about compellability is that, have you ever been in a situation where you've asked for information, either from the MOD or the then RUC, and it's been so heavily redacted, you can't make head nor tail of it. And I'm asking you as a
We've actually
judge.
got we agreed like a medical, or not a medical fact, like
MOU?
No, well, we have MOUs with all the organisations, but we ask for information. We have a template, so we're not asking for full records. That applies to medical as well.
So it's data protected.
It's targeted questions around, was the person present at the incident? Did the incident happen? So it's confirming the information we require under the regulations around the eligibility criteria. So we don't want a whole plethora of information. So the stuff that is not usually redacted. It's usually
see basically the issue is that simply that, let's say the security services could have information, okay, on an applicant that would be damaging to that applicant, okay. What we did at the very start was, I'm security vetted, but a lot of the board isn't, etc., etc. So what we said was, look, you may have this information, but there's no point in giving it to us because we can't look at it. So in essence, the absence of that type of information is actually beneficial to applicants. It means that there's less, let's say, ammunition provided to the board upon which to disqualify applicants, okay? Security sensitive information is not provided to the board, okay? So that means that you could argue that some applicants who might otherwise have been excluded are not. So the issue of redaction doesn't apply, and the issue of the provision of security sensitive intelligence information is not something that comes to the board from any state agency.
Thank you.
Okay, thank you. Brian, please.
Okay. Thank you for your answers so far, and indeed for your candid comments. And I
Maybe
would
too candid now. I mean,
it's appreciated for that. Yep. And I acknowledge you are operating within limited criteria, and that you need to uphold the integrity and consistency in the scheme. And I hear what you say about trying to include, but you'll also appreciate the frustration of those who feel people who've genuinely suffered and can't get admissibility, and we will always be pushing, for inclusion of people. You in your stats that provided, it says around 30% of applicants have currently gone as far as a determination from the board. Also, that there are ongoing efforts to increase the pace at which applications are being processed. Can you tell us how the pace is being increased?
Well, that comes back to maybe my earlier comments about we did invite the innovation and consultancy services in, and we asked them to do an end-to-end review. So they looked at every team that we have, every process, and they did. They looked at a place where there was maybe failure demand, where there was potential duplication, and then they reported back to us. We accepted fully all their recommendations, and have now started a project team to take forward that. And one of it is a new staff operating model with a new staff operating structure. So maybe we'll be looking at combining teams. We'll be looking at the level of checks that's done, on applications that come in. The enhanced IT that will come out of this project as well will also offer efficiencies. But that's not to say, even before that, we have been introducing efficiencies as we have been going along. I think it was mentioned with the groups earlier, we've held a number of workshop sessions with the groups, with officials, with panel members as well. So, and Capita have been involved in those, where we're hearing directly from the groups some of the issues. And like one of the things coming out of that was a complete review of all our communication templates, taking on board feedback from victims and from the support groups. Another outcome of that was taking forward as well as where we communicate, and when we communicate. And another thing was about the introduction of video content. That'll be uploaded to our website, and different forms of, we've got our leaflets, we've got our posters, we've got our website, we've got our FAQs, but exploring other ways of communicating with victims who maybe aren't so IT or social media, they don't have a social media presence. We're looking into all that, and then we have the support of our the committees within the board, who are the operational committee will take on certain tasks and look and see where there's room for improvement. So there's a number of pieces going on, but the big one is the project, the business transformation project.
And would you be confident that the graph of application completions will be rising as a result?
Oh, I would expect it to, and like that's one of the key deliverables for that project. The other thing, we're working with Capita as well. We're working very closely with Capita, and I know that they're putting in place a number of processes, for example, bringing in extra clinicians and extra medical staff to reduce their audit queue. One of the important things is the audit around the quality of the reports, and that will see a bigger throughput of cases from Capita back to the board, which will then allow us to list more panels and get more cases through to determination.
Okay, well, and if I can pick you up on, you talked there about communication, where and when. You'll have heard the earlier comments about where feeling there's an underrepresentation in applications. I don't know whether it's yourself or BSS takes a lead on publicising the scheme, and is that mapping taking place, and are publicity campaigns being customised?
Maybe ask Andrew after. Go ahead.
We do plan another one of our part of our communication strategy and engagement plan is, as we approach the 4th year anniversary, which is in a number of months, we'll be working with our media partners and our stakeholders in the groups and VSS and TEO, etc., to have a massive focus on awareness, raising awareness both within NI but in the Republic of Ireland, the wider UK and further afield. So we'll be doing that through a number of different forums. We'll be doing news stories, we'll probably be doing some media interviews, but we'll also be reaching out through various governments, through health agencies, churches, for as many networks as we can. We'll be doing it because we need to get this message out, that we're approaching the final year of the scheme.
So just before you go on, sorry, go ahead, Andrew.
Yeah. So, primary responsibility for communication around the scheme does rest with the VPB, but VSS have been trying our best to assist with that as well. The groups have provided lots of details of contacts outside of the jurisdiction where leaflets can be sent and posters and information can be handed out that way. You heard from 4 or 5 of the groups the first session who provide that direct support, but there's another 42 community and voluntary organisations funded by VSS, and there's a good cascade down through all those organisations to make their members well aware that the scheme's there and how they can access the support for it. We obviously have our own information on our website, leaflets that we pass out when we can. We attend other events such as Veterans Roadshows to ensure that not just the point to the scheme, but the wider health and wellbeing support that's there around the scheme. So there's a lot going on. I think a lot more that can be done and will be done as we reach the sort of the last year anniversary of the scheme.
Okay, thank you. Brandon, have you had another question? Is that you?
If you give me one more, if that's okay.
Yeah, go ahead.
In terms of the current end date of August next year, is that set in Westminster legislation?
It is.
Right.
Basically,
so it's not something that the Assembly can change on its own? Right.
Well, the Assembly can change this legislation if the Assembly wants to. Okay.
But the funding is from Westminster?
Yes. Now, the issue of the extension of the scheme, there seems to be some misapprehension that the scheme has already been extended. What happened was, scheme opened in 2021. For those that wanted backdated payments, they had to apply by
3 years, by 2024.
2024, right? We then realised that was going to leave a lot of, let's say, applicants in the second part of the scheme who would probably otherwise be entitled to backdating payments not being entitled because they didn't get their application in within the first 3 years. We went along to the Secretary of State. I remember the meeting with him, and I said, look, the deadline is coming up. We're going to spend thousands upon thousands of pounds, right, advertising the fact that this 24 deadline is coming up. can you at least tell us, are you going to extend the backdating date to the end of the scheme, or are you not? We didn't get an answer. So we then had to spend all that money advertising the need to get your applications in, and of course the backdating date was extended. So that money was wasted, right? So the
brought people in, hopefully.
What?
Hopefully it brought people in.
Well, it brought some people in, but I mean, you know, the thing is that it takes a bit of joined up thinking here, and in terms of advertising, etc., etc., we have spent quite a lot of money advertising. Yes, there's the 4-year anniversary bit. We will be doing more, but there's also a budget to be considered, you know. But the long and the short of it is the backdating date was extended to the end of the scheme, which is 2026. The end date of the scheme has never been tampered with. It's August 2026. Whether that should extend or not, that's a matter for the authors of the scheme, the legislators. Obviously, the work of the scheme, the board will continue long after that in terms of processing applications and also in ensuring payments and ensuring transfers to the next of kin, etc., etc. Should the scheme be extended? That's something I think that as president of the scheme I shouldn't comment on. I can see the arguments one way or another, but I'm clearly of the view that significant money should be spent on advertising to ensure that people bring their applications in before the deadline. But what I don't want to see is a lot of money spent on that advertising campaign to find out 2 weeks later that the scheme's extended, because that's a lot of money that could be used elsewhere, wasted on advertising. So give us a decision early on, okay? That's the key issue.
I could just add that. So on the extension of the backdating, it was a decision the Secretary of State took after the review of the scheme, which the First Minister and Deputy First Minister wrote to him to support that extension. They saw the impact that would have on the applicants and then also on the board if a huge raft of incomplete applications came in that would then bog everything down with the board going to try and get the information. So if it's a Secretary of State decision again, we'll be looking at that evidence. The ministers were happy to support the backdating one, and coming up to the last year, whether that's something that we can put the ministers' advice on that coming up closer to the time, whether they want to support the full extension, and that will depend on the evidence, the number of cases that are still on waiting lists with the group, the number of people who haven't actually managed to access the support yet to put in their application, because we've heard from Justice McAlinden there that those applications supported by groups are far better quality, which leads to a better outcome for the victims, but also is an easier process for the board because there's less gaps in the information. So that's something we'll be looking at over the next while and providing advice to ministers of something if they want to support it.
Thank you. Andrew, have you something to add, please?
That experience of the previous deadline that was ultimately extended gave us a bit of an understanding of what it feels like to approach a deadline in this kind of scheme. So we did have lots of applications that were sort of incomplete and not provided with the full support of the group. So as we move towards the end date of the scheme, be that August 26 or another date, it's about planning and mitigating towards that so that the waiting lists can come down as we approach the deadline, and we're not under pressure. The groups aren't under huge pressure then either, to do their best by individuals and get good quality applications in.
Thank you, Andrew. Timothy, please.
Thank you very much, Chair, and Justice McAlinden. I appreciate your robust opening remarks, and it was good that you were here for the earlier session, so that you could follow on and give your thoughts on that. In the earlier session, I had made the comment regarding so a victim that we have helped in the past, when we asked her to sum up the process, how she felt in one word or one sentence, it was completely re-traumatising victims.
Yeah.
So just stepping through that process again. So this was a lady that worked in the solicitor's office, knew the importance of documentation, knew the importance of keeping it. She got caught up in the bomb. She was blew up, buried alive, and left with scars and PTSD. She then went to a victims organisation for help for this scheme. So went through the process, telling her story, reliving the event, which is understandable. She got the help to make the application. She was then sent to the physical and disability team, where she had to go through everything again. So that was a 2-hour process, and then she was sent to the psychologist to go through it again. So if you're talking about making things more efficient and maybe reliving areas, that would be a place where, was there any need to get through that twice, or is that something you could get through once? So that's where I was coming from in that, and unfortunately, yes, she was able to get her payment. Unfortunately, then her husband developed a health issue and sadly passed away. And for that lady to get help through the bereavement payment, she has had to then again relive that traumatic experience. So yes, I understand you're able to debunk that, and the passion and the care that you obviously feel very, when you're president of the scheme, that you have for this scheme and the integrity of the scheme. I get that, but I want to put it, this is a direct response of somebody at 11:30 today when they're asked, sum this up in a sentence, completely re-traumatising victims. So that's the product of somebody that has come through the scheme.
And that's that's so important that I hear that. We have to comply with the legislation, which means that the applicant has to establish his or her case, right? We cannot assume harm where other schemes can. The historic institutional abuse, if you're present in an institution, you get money, okay? If you were present, okay? We have to be satisfied on the balance of probabilities that A, incident occurred, B, person was injured, C, disability has flowed from that. That's our statutory duty as a serving judge, etc., etc. I have to apply the rule of law. I cannot, although I try to, let's say, balloon out the entitlement, etc., etc., I have to, as part of my oath, apply the rule of law. Okay? Now, when we got this scheme given to us by Westminster, the whole issue of psychological injury was, in essence, just a very late tack on, okay, to the scheme. First of all, it was supposed to be only physical injury, and then someone in Westminster decided, well, we need psychological injury as well. That's fine. But the disability assessment process under the scheme, they do not and cannot give us a diagnosis. Unless there's a diagnosis on the records that they can latch on to, they are not entitled as disability experts to make a diagnosis, right? So in that particular case, it's sent to the disability to assess. The disability get all the notes and records. Disability say, hold on a second, there's no diagnosis here, unfortunately. We can't make a diagnosis. You have to, the board, you have to get a diagnosis. Either the applicant brings in a medical report saying, I have PTSD, I have severe anxiety, or I have, an adjustment disorder, something like that. Or we have to then go and get our bespoke clinician to make a diagnosis. That's not the way it should be, but that's the scheme. That's how we have to operate it to maintain, to remain within the law. So the disability capita will never give a diagnosis. They send it back to us. We then have to beg a psychiatrist or a psychologist or something of that nature, trawl through these notes and records, give us a diagnosis. If you can give us a diagnosis without interviewing this person, we want you to do that because we don't want you to re-traumatise her. A lot of the time the notes and records are absolutely paltry. There's nothing there. There's 2 notes about some sort of first generation antidepressant that you got in 1972. Okay? Well, what does that give you? Doesn't give you a damn, right? So they then have to interview the person to make a diagnosis. Now that is re-traumatising. I don't want to do that, right? But to comply with that scheme, I need a diagnosis and I need a disability assessment. And that means that those individuals have to go through that, okay? I don't want it, but that's the way we have to operate to maintain the rule of law, to apply the legislative scheme, okay? It's flawed, It has the potential for re-traumatisation. If we can do it off the records, we will. If we don't have records, we have to ask questions. That's the difficulty.
I understand that, but somebody coming with the records 2 years and 9 months, like I can only imagine not many people would have kept any records, whereas in this case the records were kept because they understood the necessity of that.
Yeah.
But for me, 2 years and 9 months now, I think we've heard part of the reason today of how quickly the scheme was set up, potentially led to some of that, and I trust that as we move forward, like looking through the stats that have been provided, 28% of the cases you have considered, 66% of them approval, 34% refusal. Hopefully in the
absolutely
the years that have ahead,
we have to improve. We have to improve.
And I trust you'll take away that case. And
Absolutely, I will. Again, I can't go in too much into the personal details of each individual case, but you got to remember that in terms of the legislative framework, the regulations, we have to give priority to people who are terminally ill or people over a certain age. Okay, so in essence, it's every application that comes in, if it's a priority category case, in other words, somebody who's terminally ill or somebody over a certain age, we have to basically put those into the accelerated pathway, to make sure that we comply with the scheme. And that, means because of the resourcing available, manpower, etc., people that aren't within the priority categories, aren't dealt with as quickly if they are complex cases. There are some cases that are relatively straightforward that can go through the scheme relatively quickly. A lot of them aren't, okay? So yes, I fully appreciate that we can do better, okay? I genuinely intend to ensure that everything that can be done to improve our processing times is done. That's why there's this whole structural review. That's why at every board meeting we go through the stats, we find out from the board members, what issues do you think are slowing this down? How can we speed it up? We try and basically improve on the hoof, okay? That's what we've been doing since this scheme was set up. We've been improving on the hoof. This structural review will, let's say, codify, I think, a lot of improvements. But we're acutely aware that these people have been waiting for years. The last thing we should be doing is to make them wait for years longer, because all that's doing is prolonging their misery, and that's not what the scheme's about. The scheme is about amelioration of harm, not the prolongation of harm.
If I could pick up on a couple of your comments that you made. One of them was about this executive taking possession of the scheme. As I outlined earlier on, I would have serious concerns with that. When you have an executive led up by a First Minister that believes there is no alternative, that has lauded terrorists, I don't think this executive should have anything
There
to
are
do
fundamental
with
issues in this society, fundamental issues that are not addressed, but they have to be addressed. And I appreciate where you're coming from. I appreciate the strength of your views, etc. I know that those views are opposed by other people, etc. But, we have to try and move forward. We really do. Okay? Everybody has to try and move. Okay?
If I could pick up, you had mentioned in response to another question that when you've requested information, you're not getting intelligence briefing essentially attached to that.
Yeah.
And that has actually helped the victim in a way that if you had that intelligence briefing, it might have made them...
Well, we don't know because we haven't got it. We can assume, we can sort of, let's say, well, perhaps there would be information in relation to this individual, but the security services haven't provided that information. Therefore, we just have to take it on face value.
There is a possibility that perpetrators might have ended up getting money out of this scheme because the
usually what happens is the security services will not provide information, but the PSNI will usually have, let's say, some reference to involvement or whatever in the report which can be utilised, okay? But it's let's say the security services will not provide information that would be classified or anything of that nature.
And my final comment is that it's easy for people to point the finger at the state because they have all the records and the details of what happened, whereas the perpetrators of the terrorists that inflicted years upon years of terrorism in this country didn't keep any records, and that's something that's easy to point the finger at the state. But while we have terrorists walking about that are lauded by our First Minister, this country certainly will not move forward and will not get the truth and justice.
No, you know, the point I will make about that is, irrespective of any view that you have about the First Minister or anything the First Minister says or anything any politician says, right? This whole legacy process is flawed in the sense that there is an absence of openness in relation to the victims of paramilitarism, okay? That is a continuing sore, a continuing cause of hurt in our society, okay? Legacy must embrace everybody, okay? The openness and transparency that is required of the state should be required of those who perpetrated horrific acts of violence in the name of a political cause, okay? There is an hypocrisy involved in those who berate the state for not providing information, for not opening up, and at the same time do not require the same standards to be applied to those non-state entities that engaged in violence. That's part of the problem in our society. That problem has to be addressed.
Can I just before I bring Harry in, just on that? So you talked about improving this on the hoof, and we've had ICRIR in front of us a couple of times, have been very gracious because they don't, they're not accountable to the Executive Office. But I'm just wondering, to what degree has there been engagement with the NIO or ICRIR in terms of how they can learn from the process you've been through?
Declan Morgan appointed me to this role.
Okay.
So we've met. We have agreed any information that we have, right, that he requests, he will get. Okay? It's about ensuring, giving his organisation the best opportunity that it has to meet the needs of those that are seeking answers in terms of how their loved ones met a horrible end. So, in essence, I have reassured him at the meetings that we've had that any support that the Victims Payments Board can give his body will be unflinchingly provided. And we have a good working relationship. A, he appointed me as a judge, and B, he appointed me as president of the scheme. He obviously didn't really like me all that much. But we have a good working relationship. I admire the man, I respect the man entirely, and I will do everything that I can as president of the Victims Payments Board to ensure that his body is a success, because it is an element in trying to address the past and trying to allow us to move forward.
So thank you for that. I suppose the second part of it was, to what degree has the NIO approached you for some of the learning in terms of how they're looking at the changes that they're looking at for the Legacy Act? Have they lent in to say, could you please?
No, they haven't approached us about legacy at all. Any time that we've tried to engage with the Secretary of State, previous Secretary of State, I haven't met the present Secretary of State as yet, but the previous Secretary of State, it was all about trying to persuade the Secretary of State in terms of making a decision in relation to the backdating, and also addressing what we would regard as easy fixes in terms of errors or omissions in the scheme. So we've had those engagements, but we've had no, let's say, meaningful overall strategic dialogue about how this scheme could be positively improved to address what we see are fundamental issues.
No, that's a really important point. Go ahead, Andrew, and then I'll bring
And
Harry
just again
in.
a tangential point.
No, you're okay, please
the,
do.
just on the concept of the learning from this scheme, we're obviously working towards a redress scheme within mother and baby Magdalen laundries and workhouses. So I think there will be a very different scheme, obviously, but there will be opportunities to learn from some of the approaches that have taken place here and through the HIA redress scheme as well.
Okay. Well, obviously, Patrick, that's something you'll be taking on board as well. Sorry, Harry, thanks for your indulgence.
Okay, thank you very much, Chair. Thank you, gentlemen. As you probably heard, my chat with a previous witness about 2,100 applicants, 1,300 of them, as he described, were good. That still left 800 put through trauma that I'm sure they could well do without.
Yeah, well, I think, would they have said that it was traumatic if they had been successful? Some are successful and say, yes, it's traumatic. But I think that there is a significant, let's say, disappointment and potential for re-traumatisation, not in relation to the progress through the scheme, but in relation to the outcome. Okay? If you build your hopes up, if you get a support group to say, right, we'll put in an application, even though it probably doesn't fall within the scope of the scheme like a lot of the bereaved applications do. I mean, support groups are trying to push the boundaries, okay? So they're pushing people into the scheme where they probably know, well, look, it's not going to go well for them, right? And then they're saying, oh, this is totally re-traumatising. But why is it? Because you push them into the scheme because you want to push the boundaries of the scheme, which is an understandable situation, okay? So when you say about re-traumatisation, you've got to look at, is it re-traumatisation through the process, or is it re-traumatisation through the disappointment from failure? And is that disappointment from failure as a result of being pushed into a scheme where the scheme is not designed for you, but people are trying to expand the scope of the scheme? And I understand why they're doing it, okay? But so the concept of re-traumatisation is one that's multifactorial, okay? And what we can do and what we should do is ensure that the process is not re-traumatising, or is as absence of risk in terms of re-traumatisation as is possible, and ensure that the duration through the process is as short as possible. I think those are the two features that we can try to minimise the risk of re-traumatisation, but there are other factors outside our control in terms of re-traumatisation.
And can I just add to that? There's also the other issue that the groups have to deal with, where people are coming and they genuinely believe they're an eligible victim under this scheme. The groups will do their best because they're very knowledgeable on the regulations. There are occasions when the groups do their best to explain, listen, this is potentially outside of the criteria, but the applicant is insistent that they put the application in. So the groups are also having to deal with that as well. I've spoken to a number of the groups and that also adds to the disappointment. But the groups do their best as well to maybe, in cases like that where it's maybe clearly out that, listen, this is not going to run, this is not going to meet the criteria, but the applicant or the individual is insistent, and it's maybe whether they want to tell their story or whether they just believe that it should be put in with a view to appealing it and with a view to maybe getting the regulations changed.
Patrick?
I'll just add that I think something that the groups do very well and it's very important to keep emphasising is even if they haven't been successful with the scheme, that's not the end of any involvement or any support they can get from government in general. I know Andy would say the same, the regulations for this scheme and the eligibility is different to the Victims Order 2006. There is the bereaved scheme that we have for annual payments out through the self-directed assistance through VSS that is put in a couple of £1 million out every year to people which are less stringent. It's obviously not as big a scheme, it's not a statutory footing, it's not as secure as something like this is, but it is something for acknowledgement, plus then all the available services and support that applicants who meet the 2006 order, which is wider than the victims payments one can get. So I think it's very important that even if they're not being successful through the RTN, through the BSS and through the funded organisations, there's a lot of support still there for people.
I was also going to say, my question would have been, was the bar too high? And I'd also like to comment that Justice McAlinton as President, I really do feel that although you couldn't lower the bar as such, you certainly done your best to help those over it.
Well, look, I'm grateful for that recognition, but at the same time, I do not rest easy hearing stories about those that have negative experiences going through this scheme, and I certainly don't rest easy with the concept of limiting the recognition of this scheme to those that were injured, and knowing that there is a pool of victims in our society who suffer bereavement, who are in essence left outside the scope of a bespoke scheme for them. It is unconscionable that that remains the case, and I do not rest easy dealing with a victims payment scheme where I try to shoehorn in as many as possible, knowing that in doing so there are many others who feel for arbitrary reasons that they are excluded. Okay?
Yeah.
So in trying to help some, I know that I'm causing or potentially causing re-traumatization to others, and that's a terrible thing to live with.
Okay, Timothy, did you want back in, Timothy?
Yeah, just a quick one. Can you set out how the applications are considered? I think it was yourself, Justice, had mentioned the word category. So are the applications considered in the date they come in, or are they placed in a category?
The date they come in apart, they are in date order. As Justice McAlinton said, some of the applications will naturally progress through the system faster than others as we receive evidence, or depending on how full the evidence is when we receive them. However, there's two categories where they're prioritised: for those who are over 80 or those who are terminally ill.
Mm-hmm.
Now, if they're over 80 or terminally ill at the time of application, they're prioritised straight away and they're flagged throughout the system. They're flagged with our information provider partners, they're flagged with Capita. That's treated as priority throughout. But if they turn 80 throughout the process, our systems will flag that up straight away, so they automatically move into the priority stream. Or if we receive information, medical information that they've been diagnosed with terminal illness, they will move from the ordinary stream of applications into the priority category. But there's no other category, there's just the priority category and then but applications do proceed through at different paces, just because the information becomes available sooner in one case than maybe another.
Okay.
We point of clarification. Patrick, can you just clarify the scheme that does exist for the bereaved?
Yeah, Andrew, maybe we want to say
Andrew, yeah, go ahead.
So self-directed assistance, that's an annual payment made by VSS to over 6,000 victims and survivors who are either injured, bereaved or carers, and it's a much more modest scheme. It's £500 or £1,000 per year to those people. It's come about as a legacy scheme coming out of, I believe, the Northern Ireland Memorial Fund back many years ago, and that the only part of that scheme that remains open is for the bereaved, in recognition that they may find themselves unable to apply to this scheme. The other parts around injury are now closed to new applicants, and we point individuals towards the TPDPS.
Okay, thank you.
Okay.
Justice McAlinton, a question's been burning in my head this whole session today, and it's been around the troubles-related sexual assault. And we know that in Northern Ireland, the prosecution rate is so low, even whenever there is a degree of evidence. How do you think that this scheme could be improved, or a new scheme, similar scheme set up that would allow for women, obviously particularly women who've been subject to rape or sexual assault, to be able to apply and be successful where they're not able to be successful in the courts? Like, is there a way that you think that could be possible, especially given the history?
First of all, there's the Criminal Injuries Compensation Scheme at present, okay? And Criminal Injuries Compensation Scheme does not require a victim of sexual violence to have successfully achieved a conviction in court. All that is required is that the and Paul was intimately involved with the criminal injuries compensation scheme before transferring over into the Victims Payments Board. But so he'll be able to correct me if I speak out of turn. But in essence, as long as there's cooperation with the police, there is the entitlement to claim under the criminal injuries scheme. So there is a bespoke statutory scheme for victims of sexual violence already, which does not depend on a successful criminal conviction.
Okay, no, thank you. That was just. Did you want to add to that, Paul?
No, I was just double checking because Alan also worked in criminal injuries company, so
appreciate that. But I do take it as a wider societal issue in terms of women coming forward. Okay, that was some session today. Thank you so much. I have just one last question for you. I forgot. When are we getting our Victims and Survivors Commissioner?
Well, the interviews, the ministers have interviewed the candidates, so waiting for we got white smoke last week, maybe white smoke. So
hey, we can live in hope. Okay, thank you guys.
I've interviewed you, the interviews are complete, so waiting for an earlier decision.
Okay, gentlemen, thank you so much for your time today. Really appreciate it. Okay, members, so just a couple of issues just to tidy this up a bit. So as you are aware, Hansard have been here through the proceedings. I'm just wondering, can I get your agreement that we share the Hansard report with the Justice Committee afterwards with the crossover? And then I'm just going to ask the clerk to recap on what actions or what potential things we could be following up on, because it was quite a session there. I just want to capture it before we leave today. Go ahead, please.
Yes, thank you, Chair. There are a number of things that came up that I've noted down, but it may well be that there are more that we need to follow up on. The first one was mentioned a number of times, was the mapping exercise around both geographical but also sectors of and whether or not, if that hasn't happened, whether it plans to happen or whether anything has been done in that, so we could follow up to find out about that. There was then, I also had down the end of the scheme and the funding that perhaps would need to continue once we'd gone through the deadline of the end of the scheme, and whether or not the committee were keen to get more detail on that as to what plans were in place now, because although it's a year and a bit, it'll be here before we know it. And also whether they had any more sort of detailed thoughts about what they wanted to do on that. So if members are happy, we'll follow up on that.
So just on that, are you talking about even if it does end on that date? Because it'll have to carry on for a couple of years or 2
exactly.
years.
And that's
what you mean.
I do, and also the funding around the support for applicants that are in, but the process hasn't for them, and clearly there is a fairly long timeline on that. So it's just really to pick up on that and get more information about that.
Is there an appetite for the committee to write to the Secretary of State? Obviously, he's the man that determines the end date. That's set as 30th of August 2026, or much later, or such later date as the Secretary of State may determine. Do we want at this stage to make representation?
My understanding was that from Patrick that they're possibly going to look at this with a view that they're going to give advice to the First Minister and Deputy First Minister around whether the scheme should be extended. So I wonder, is the first port of call to go to the First Minister and Deputy First Minister to see what, to get a wee bit more detail on what Patrick was outlining there in terms of their own timescale around it?
The last time the date was moved, was it a case of the Secretary of State made the announcement and they welcomed the announcement? So it was almost as if he's already made the announcement and then welcomed it, whereas if we could put a process, if the mind of the committee is, if we go to if it's Secretary of State directly or through the First and Deputy First Minister, there's no point waiting till he makes an announcement.
Both.
Well, I suppose it's around what lobbying it's done, and I think the Assembly might have been suspended again for good. I think there's that factor to be factored in. Let's go right to vote. Yeah, no problem.
And I think the point that Mr. Justice McAlinden made about, do we now spend public money on advertising the scheme and a substantial amount of money, or if you are genuinely going to consider an extension, then that money best be saved?
Yeah, I would have liked to have seen today the number of applications per month and whether they're tailing off, because when we went around the extension of the redress board for historical institutional abuse, they said they've really tailed off. So it's whether there's the justification But again, if they're not advertising it properly and they're not getting into the right communities, and
It is going up, according to that chart.
It's still relatively low how many applications they've got through.
yeah.
Regarding the communication strategy,
That's the next one I was going to come on to.
so Stuart has mentioned about the waste of money if we're going to go out with 2026. Like that money could be invested to reach out to other areas. Yes, it's leaflets and posters are all well and good, but when you look at and I raised this previously, was the abuse scheme from the Republic. Like they had ads at the tube station in London. I presume there's nothing like no graphics, nothing like that has been produced. Whereas that would be a better use of money to use this time to actually make people aware of the scheme. But you need the clarity. Well, when's it going to close?
Yeah, yes, that's one of another area. The whole communication strategy for the witnesses referenced around the 4th anniversary, but I think that does tie in with then the closure of the scheme, and obviously there had been experience in the past where they had spent money to then find the scheme was extended. So again, committee can follow up on that and try and get more information about the plans that are in place.
Is it possible to write to the groups, and this is something I meant to raise earlier, asking them for communication strategy, everybody's talking about it. What does it need to be from the victim point of view, from the victim group point of view? What's their ideas of how we reach more people?
Yeah,
Again,
no, absolutely,
that,
absolutely.
Yes, we can, that's no problem. Just a couple more, Chair, that I had down. The case management system that the Deputy Chair raised, and it appeared that there had been some sort of audit carried out by, I think, the Audit Office. I wondered if committee would like to find out more about that, and we can follow up on that to find out exactly what the results of that was in relation to.
Go soft or hard then at that point, because you can see they saw that, but it was okay because they were doing other things, or else it is an area they need to go and look harder at.
So again, happy with that. We will do that. And well, I also had down the Commissioner, but we actually got detail at the end. It appears that they're in the final throes of that, so I don't. We'll see. I mean, we could write to TO around that, asking for an update, if members wished, and that would give that. And the only other area I had was, again, that I think it was Paul had mentioned an upcoming structural review of the administration of the scheme itself. I wondered whether the committee would have benefit of finding out more detail about what was actually included in that review. Yeah. But again, that's something for committee to agree.
Okay. Any other suggestions?
Anything else that I didn't get?
Okay. I was sort of looking at that graph again. I wasn't sure whether that was the almost cumulative total.
Well, I think it is, but it's still. I know it's slightly. It's still. You would say it's exponential. It's.
But I'm saying is that
the rate of increase is increasing.
Yeah. Okay. But I still think maybe we should ask for a bit more detail in terms of number of applications, number that have been rejected.
Yeah.
Or people have withdrawn from the system. That. So I think just a wee bit more detail. Okay, members, I have an event at Queen's and a balance against women and girls at 6. So if we're okay, I'm going to move on. Okay.
Can I just ask you, are there any more actions? Committee happy with those ones? Great.
Okay,
thank you.
Okay, so thank you. So correspondence then, members, I'm going to refer you to pages 95 to 99 of the pack for the summary, and I just want to draw your attention to a number of items. So 9.2, the individual response to correspondence on the 30th of April regarding gender perspective in the truth recovery process. So the committee has received this correspondence from an individual regarding the truth recovery process, so just to advise that the information contained within this correspondence relates to the issues raised in the closed session by the individual earlier this year, and so a draft response for members' consideration has been tabled. It's in front of you there. But if members want to discuss this, I wonder, it's because of the number here, whether we should maybe try and get agreement via email after the meeting.
That's practical.
Is that okay? Okay, because I think we might have to otherwise go into closed session, but I think that's probably better to do that. Okay, so committee 9.6, Committee for Infrastructure. So I'm going to refer you to pages 96 to 98. So the committee has received a memo from the Infrastructure Committee, including a copy of a letter from the Minister of Finance regarding disaggregation of £425 million allocation made by the Executive to deliver priorities within the programme for government. The Minister's letter contains an updated table which reflects £440 million of allocations to PFG priorities, including reference and capital DEL across the draft and final budget. The TO, the 2025-26 budget outcome, £2 million has been allocated for ending violence against women and girls. So I'm just seeking your agreement to note this and to write to the department to ask, following the disaggregation of £425 million allocation made by the Executive to deliver the priorities within the PFG, how the £2 million allocated to end of violence against women and girls will be spent. We agreed?
Agreed.
Okay, so then the next one, 9.9, Mid and East Antrim Borough Council response to correspondence of the 9th of May regarding the Local Change Fund, and you'll find this on page 126 of your pack. So this Local Change Fund is in relation to local projects for ending violence against women and girls, and the council has made 100,000 100,000. Yes. All right. I'm getting tired. Available within the grant scheme, which closes for applications closed for the applications on the 9th of May. To date, there has been 1 complete application and 20 in progress. So assessment will take place following the closure of the scheme and awards made accordingly. If all funds are not allocated, a second round of the scheme will open. So I'm just asking you to note this, but I think that given that we are still waiting responses from all the council areas, I think we would just maybe hold that correspondence, and then we can review it as a composite then.
Is it possible to get the criteria?
Next question. And is that common criteria across all local authorities?
It's the same thing again that been raised by members, that the money has been given.
Previously, so we're waiting on response.
Sorry, Sarah Ann has the answer to that.
Yes. No, Timothy, I was just going to say that we wrote to the department to request that correspondence when we considered that on their meeting on the 7th of May. So that letter's still outstanding from the department, and that's just one of the first responses we've received from the 11 councils that we've written to. And as the chair says, we'll collectively consider those once they're all in, but we have asked about the criteria.
The concern is that the money has went, and I've said this regarding numerous schemes, the money's going to the council. It's really you make your own scheme up to try and fit it, whereas it should be driven from here of what we want to see.
Well, I think once we get all the information, we'll probably be able to make an assessment as to whether we actually think that has happened and whether it's.
Well, we could ask what criteria.
Yeah, that's what I'm saying. We have done that.
Yeah, we have done it.
Yeah. Okay, I'm just going to ask the clerk to run through very quickly the rest of the correspondence.
Okay, thank you, Chair. Item 9.3, SR number 78, Northern Ireland Climate Commissioner Regulations, Northern Ireland 2025, and SR number 78, Explanatory Memorandum. It's just a notification that the statutory rule was laid in the Business Office on the 6th of May. It's for information only, and this actual statute rule is not subject to an assembly procedure, but it's just to make members aware. Item 9.4 was an Executive Office news release about ministers unveiling the first phase of the £100 million investment at Belfast International Airport. Again, just to note. Item 9... Sorry, go ahead.
Sorry to interrupt. Was there a public fund element to that, or was it just private sector investment by the airport itself? I wasn't clear.
Yeah, I don't think so. I think that it's more just because it fits in with the international strategy.
No, it's very welcome.
Yeah. No, I don't think that there was any public money put into it.
Okay.
Would you like us to ask?
Well, even just of officials, I suppose.
Yeah, we can ask, because as I said, it does fit in with the international strategy.
And it's important that we develop the transport infrastructure, but it's if it's all private sector investment, it is a substantial investment.
I think so, but not 100%.
Yeah, let's check that.
Yeah, I appreciate that, there is a subsidy sometimes goes, to airports, as we know.
Boost tourism, absolutely.
Yeah.
Yep. Okay, please go ahead.
Thank you, Chair. Item 9.6 is communication from the Children's Law Centre, just an invitation to a webinar that they're holding, and if members wish to take part in that, the link is available in the correspondence. Item 9.7 is the Executive Office response to committee's correspondence from the 19th of March regarding the Budget Sustainability Plan, and again, that's just for members to note. Item 9.8 is a Department of Health response to the committee's correspondence from the 14th of April in relation to end-of-life care for victims and survivors of historical international abuse.
Institutional abuse.
What did I say?
International.
I'm so sorry.
Okay,
Institutional abuse. Apologies. Item 9.10 is correspondence from the NI Assembly EU Affairs Manager regarding EU scrutiny arrangements. There is a copy of the letter from the Paymaster General and Minister for the Cabinet Office, Nick Thomas Simmons MP, to the chairs of the House of Lords European Affairs Committee and Northern Ireland Scrutiny Committee on the 24th of April, seeking their agreement on a renewal of the EU scrutiny arrangements which were agreed previously by those committees in October 2022. Again, for members to note. And item 9.11 was an Executive Office news release, and that is FM and DFM congratulating Pope Leo XIV on his election as the new head of the Catholic Church.
Okay, anybody want to raise anything about any correspondence? No? Okay. Okay, so draft forward work programme, you'll find this on pages 136 to 138 of your pack. I'm just going to ask the Assistant Clerk to talk through any changes. Thank you.
Thanks, Chair. So it's just one update, and that's regarding arrangements for next week's meeting. So we're going to meet earlier at 1:15 next week, and that'll be an informal working lunch with WAVE, Adopt NI and VSS. And that's just them to give an overview of their role supporting victims and survivors in mother and baby institutions, Magdalene laundries and workhouses. So the formal committee meeting then will begin at 2:30 following that, and there's just the one oral briefing then with, which is an update from the overseas bureaus, and they'll obviously be given that update virtually.
Perfect.
Okay.
Thank you. Any questions? Go ahead.
Just one to raise regarding the updated paper legacy in the Republic of Ireland. I see it's TBC for some time in autumn. If the legislation doesn't arrive and take up committee business, is that one we could look at to bring forward? Autumn seems quite a way, a distance away, and if we can look at bringing some of them forward, especially that one if possible,
Yeah.
in the event that legislation doesn't appear.
Okay. Okay, any other business members? Okay, thanks. Thank you very much, everybody. Just going, oh, sorry.
Date and time next meeting, if that's okay. Just a bit.
Oh yeah, so next meeting is it actually the official meeting starts at 2:30 after the informal session. Okay, thank you. Okay, I'll send.
Committee Room 30, sound.